The petitioner is a retired employee, lecturer. His break period has been not regularized since
1987 to 4990. That is left out.
In respect of the same, you also kindly have a glance to Annexure 7, page 21, minus. Page 21. On the basis of the director of the government, as per director of the, as per policy of the government, the deputy director wrote a letter in persons of the regular.
It will declare to have been
validated from 67, 84 to very small prayer manner. Due to that, he is unable.
Have you given any representation?
Yes, my lord. That is 15. Annexure 15.
Petitioner's prayer reads as petition prayer reads as first of counsel for the petitioner draws attention of the court to the representation dated.
Drafted, my lord.
The previous.
Yeah, 24. 2010-2024, my lord.
2024. Wherein a copy whereof avails at Annexure 15. Wherein
Honorable, it is Honorable Director of the number 2.
Yes, question. OP number 2 to grant redressal by counting the break-in service as service in terms of which is that order relation?
Annexure 7 and 8.
In terms of orders dated 1911-1996 and 1912-1999 respectively at Annexures 7 and 8. Council submits that if
7 and 8 also, man.
Correct. Submits that if a direction is issued for consideration of the same in the light of the said annexures, is inclined to be happy. Next paragraph. Mr. Lenka, on request of AGA, on request appearing for opening of OPs, very fairly submits that he would instruct OP number 2 to look into the grievance of the petitioner in a time-bound way and in accordance with law. If all conditions are kept open, first of all, this proposal counsel for the petitioner concepts. Next, solicitude.
Item 2, may I please? The petitioner date of birth in the board certificate has wrongly mentioned at Annexure 2.
In which certificate?
Board certificate issued by the Board of Secondary Education Orissa. That is Annexure 1, my lord. Wrongly, that has been mentioned at 8 April 1999. But that will be as per
71 or 75.
75.
Take notice.
Well, it's a very small matter. He is waiting for the pension because of the wrong date of birth. He is not getting. So direction may be given to the OP number 1.
They are
my
one panel of council. They have to notice.
No, notice has to.
My lord, my annexure is at 4.
Correct. But if you bring a council, I can do it. We'll issue notice and bring it in a week after next.
So very short that we kindly thought.
Issue emergent notice. Who appears for OPs?
Mr. Senior Advocate, Mr. Rao, SS Rao.
SS Rao, the next thing is for 1 and 2. Emergent notice to 3. Post immediately after service, since short point is involved. To bring that judgment, the consent judgment, which I have held, na? Yes.
Item 3, that kindly
Yeah, is an option.
that we kindly fix.
Yeah, is an option. The present petitioner is working as a junior clerk in an aided institution. Initially, the petitioner has approached the learned State Education Tribunal for approval of his post.
Notice is the question the granting.
It can also be disposed of, or will permit. It can also be disposed of. Why I'm saying so, by Annexure 1, the tribunal directed to release the grant in aid in my favor. Under Annexure 2, I filed the execution case which was allowed. And Annexure 3, they have already approved my order of appointment. Subsequently, the matter crept up that another incumbent claiming to be a junior clerk in my college, under Annexure 4, he challenged my order of approval. Subsequently, it was dismissed. Even after dismissal, Your Lordship, the government is not approving my post, which has already been approved by Annexure 3. So my consideration is that under Annexure 5, Your Lordship, I made a representation.
Item. Petition prayer reads as above. But counsel for the petitioner draws attention of the court to the client's representation dated
It's dated
21.
22/12/2024 at page number 28, Your Lordship.
at an exact
5 series, page 28.
First one. One such representation addressed to the Principal Secretary, Higher Education Department, Government of Orissa, reads as under. Next paragraph. Counsel for the petitioner submits that if the direction is given to consider the subject representation in the light of OJ, what is that? OAB order.
That is GIS case number
CISC case number 77 of
2008.
8, comma, is client would be satisfied. First, with this proposal, alternate AGA appearing for OP number 1.
OP number 2,
OP
Your
1
Lordship.
and 2.
1 and 2.
1 and 2 is also agreeable, subject to the caveat that all contention should be kept open and a reasonable period should be prescribed for accomplishing the task. First, this is reasonable. Next one, ethics.
Upgrade.
Item 4. May I please your lordship?
Yes, sir.
And that is petitioner is your lordship interfere the honorable court, your lordship. The Pradhanamantri Ausada Janak Kendra, my lord. My brother elder brother is a disturbance to me, my lord. So we have filed this.
Party number 2, not to disturb the petitioner.
Malady.
Into his medicine shops, namely,
Yes, my lord.
coming in the way. OP number 2 is who?
No, my lord, my elder brother, my lord.
How elder brother? If you have a case against elder brother, it is not maintainable.
Yes, my lord, I am admit, my lord. I am admit, your lordship.
Then I cannot admit the writ petition.
Because, my lord, it is Jana Ausada Kendra, my lord. It is Pradhan Mantri Bharatiya Jana Ausada Kendra, my lord. It is public medicine shop, my lord.
Correct. How? Your brother is not a state entity under Article 12.
Yes, I mean, my lord, maybe direction may be given, my lord. Appropriate form may be given, my liberty may be given, my lord.
Petition prayer reads as that. First, the grievance is made against a person who does not answer the definition of state under Article 12 of the Constitution of India in the light of R.D. Shetty, International Airport Authority Limited. First of all. Therefore, petition is disposed of, reserving liberty to the petitioner to work out his remedy in accordance with law elsewhere. First, in that connection, all contentions are kept open. Okay, next.
Item 5.
May I please, Your Lordship?
Yeah.
In this case, the petitioner has participated in the recruitment process of trained graduate teachers published by the State
Why
Selection Board.
notification?
Your
What
Lordship,
is that notification? Annexure 6?
Your Lordship, that is final merit list. I have
Final merit
qualified the written examination. I have called for the document verification. After document verification, the final merit list was published. There, my roll number was not there. I have filed RTA application to know why I have been rejected. They have not given.
What is your score?
I don't know because they have not published anything.
Yes, file a representation, annexure 10, before
Your Lordship,
the
that is-
Secretary State Selection Board.
Yes, my lord.
Lordship may have this one.
No, Your Lordship, notice will be given because earlier I
You have
have.
given representation and you let them consider. It is only a final list. Appointment orders are not yet issued.
No, already issued. They have
Issued.
already selected. I have approached this honorable court earlier. Your
No,
Lordship,
whether
Annexure 9 can see for a moment.
whether
That was withdrawn.
appointment orders are issued.
Yes, my lord.
No,
They are issued.
that was annexure 9, page 57.
Annexure 6.
Subsequently withdrawn.
Withdrawn also.
Yes.
No, that is a file the objection to the opposite party number 2. The petitioner after verification document in terms of Annexure 5. Without any reason, his name has not been included in the final list. As per this order, I have approached the opposite party number 2.
No, you had
Admitted
before
to
the
it.
court earlier.
Yes, my lord.
In that they gave a direction.
Yes.
What is the order made on that representation now?
No order has been made.
Then I will issue one more order and they will not pass any order. How many writ petitions you want to file? You have to go for contempt. There is already an order in 13177 of 25.
Yes, my lord.
And now again you have filed the writ petition. What for?
Because it has liberty has given to file the objection, I have filed objection.
Objection, but no decision is taken on that.
No decision is taken.
Your objection is where?
Annexure 10, my lord.
Annexure 10.
Yes, my lord.
Let them consider this.
Yes, that's true.
Yes, my lord.
Petitioner's essential grievance, regardless of the prayer columns, is as to non-consideration of his representation dated 5/8/2025 at Annexure 10, made to the Secretary of State Selection Board, Odisha, Bhubaneswar. First up, who appears for Selection Board? You appear. Learned counsel for the petitioner submit that his client should be satisfied if a direction is given to consider the state representation on merits within a reasonable time. First up, with this counsel, AGA Mr. Lanka is agreeable, subject to the caveat that all contingent should be kept open. First up, this is fair. 6 weeks. Okay.
Item 6.
May I please allow the petitioner, she has retired from her service since 2021. Her claim is for final pension. Now,
Provisional is given.
provisional is given, Your Lordship.
Issue emergent notice. Lanka accepts notice for 1, 2, 3. Emergent notice 4.
May come along with WPC number 15390 by 25.
Yes, Your Lordship.
Next.
Thank you, sir.
Item 7.
Your Lordship, my lord. In this case, my lord, petitioner applied for the post of classical teacher.
Classical teacher.
My lord.
Sanskrit.
My lord. She was selected, but in the counseling, she was not given the appointment on the ground that in the OTT certificate, the subject stream has been written as trained graduate arts, my lord.
Trained graduate.
Arts, my lord.
But you are not a trained graduate.
My lord, I have passed, I have applied for the classical teacher,
That's all right.
passed in the OTT examination.
What is the requirement?
My lord, requirement one is a bachelor in the arts with the Sanskrit honors. All qualification I have got, my lord.
Show the qualification.
My lord. Thereafter, I filed a writ petition before Lord.
Show me the, before going further.
My lord.
Please
Your
show
lord.
me the
My lord.
prescribed qualification.
My lord. Everything I have possessed, my lord.
Only thing, but you should show what
My
is
lord.
the
Only thing is, my lord, your lordship kindly see page 38 annexure 6.
38.
This is the only thing, my lord.
No, not that.
My
What is the prescribed qualification by the notification?
prescribed, my lord, I was selected only in this deficiency in the, my lord. The lordship kindly see, my lord.
Question.
My lord.
Learned counsel for the petitioner
My
is
lord,
not answered.
my lord, your lordship kindly see, my lord. My lord, sorry, my lord, page 25 now.
20.
25, my lord.
Sanskrit with minimum 50% of marks and aggregate 35% from recognized university and Shiksha Shastri. The course prescribed by NCTE from the. Do you have that?
My lord.
What do you have?
My lord. For which I was selected and I was enlisted in the list, my lord, merit list, but in the counseling,
Why they have not?
my lord, your lordship can see page 38 annexure 6, my lord. Page 38 annexure 6, my lord. This is the OTT certificate.
Why Mr. Lanka not considered?
That he needs to be get it corrected
By the
from the
board.
Board of Secondary Education.
What correction he should do?
Your Lordship may kindly see page 38,
38 annexure 6.
the last stream, last line, stream trained graduate teacher. That should be classical teacher Sanskrit.
But anyway, other marks cards and other things are there with you.
The certificate will
Your lordship also kindly see.
go board to his grievances against the board.
There is mistake in describing him as a trained graduate arts is correct. But if you see other marks cards and other things, that it is obvious that he answers the requirement.
But the certificate will come all along the way. Let him, your Lordship, may direct the board to make necessary correction.
Only annexure 13 page 57.
13 page
Page 57. In the OTT examination, my lord, I have also answered in the answered this classical Sanskrit subject, my lord, said to be page 64. In the
But
exam,
they are saying that you get the.
but while filling up the form, she has filled up as 10 graduate arts, my lord, in place of classical technique. But he has answered classical Sanskrit in page 64 question paper, lord. So you kindly see, I have annexed.
You take notice. Issue. Are they filling up the post now?
No, one post, your lordship, earlier I have approached your lordship. Your lordship directed the director DO to consider, and one post kept vacant, my lord. That post is still vacant, your lordship.
Issue emergent notice. Mr. Lenka is requested to accept notice for 1, 2, 3, 4, 5.
All which separate can.
5, 4.
Yes.
Emergent notice to 5. First of all, an application in IN number 19138 of 2025, supported by an affidavit is moved seeking interim protection, apprehending that if the post in question is filled up, that may create other problems which are otherwise avoidable. First up, in the earlier round of litigation, this court had granted interim protection, submits counsel for the petitioner. First up, the case is made out for issuance of the protection. Next up, in the above circumstances, application having been favored, copy number, who should be directed? Copy number 5 is directed to keep one post.
Open 3, my lord.
Correct.
Copy 1?
No, my lord, OP 3, my lord.
Copy 3?
3, my lord.
Copy 3 is directed to keep one post vacant. First, matter lies in a narrow compass, call in the first paper, January. Yes.
One post classical teacher Sanskrit.
One post of classical
Teacher Sanskrit.
teacher comes. Okay. Always when court asks a question, should not avoid that. You should face the question. Yes.
Item 8.
I have challenged the Honorable Annexure 13 matter that the rejection order with respect to sanction of MSA benefits, my lord. According to statutory rule, my lord, on completion of 30 years of service, taking into account the date of initial entry into the service, my lord, I have entered to get
Vijay Kumar Mahapatra.
Yes, my lord.
Issue emergent notice. DGA is requested to accept notice for OPs. Okay. Next.
Item 9.
Yes.
Rules here. This notice shows
Cabinet petitioner. Let them serve a copy of
You copy.
tomorrow. So maybe take out to.
Look into your to read even cursory reading. See how big it is.
1 week, my lord.
One. Next week.
Oh,
Copy.
will also not fix up the day. So that can.
Where is the cremator's name is shown here?
No,
My lord, my.
is a name it there.
Okay. Next week.
Item 10.
Yes.
Instead of requiring 18 months diploma course, has been for one-time dispensation equivalent to 2 years as per direction of the Honorable Supreme Court. And on the basis of the judgment of the Supreme Court, the NCT,
Yes.
National,
You have to take notice.
No, your lordship.
It is being covered.
No, not covered. Your lordship and batch of case was directed to listed on 24/11.
Therefore, you take notice. On 24th level, we'll
Yes,
this matter.
yes, this matter. Your
My
lordship.
lord, my appearance on behalf of opposite party number 1, 2 and 3 may kindly be recorded.
Issue notice. PGA. Mr. Lenka, I request you to accept notice for 4, 5, and 6. Learned counsel. CGC.
Senior panel counsel.
Senior panel counsel, Mr. Soin, sorry, notice for 1, 2, 3. 1, 2, 3.
My lord.
Okay. 1, 2, 3.
WP
All this matter along with WP number.
21675/24 and batch.
Okay. Yeah.
Item 11.
This is challenging the irregular reservation of women pursuant to advertisement under Annexure 1 and 2 for junior teachers in matric.
Rajesh Kumar Dharia is violated.
Your Lordship, similar matters is
We have already
pending.
issue notice. Learned AG is requested to accept notice for OP numbers 1 and 2. Emergent notice to arrest. Call along with WC number. Next. I compare.
No, it's not given so that petitioner was arrested in connection with a criminal case on 12/9/2025.
Voice is not audible.
The petitioner was arrested in connection with a criminal case on 12/9/2025. He was released on bail on 23/9/2025. He submitted his joining report on 25/9/2025. His joining report has not been accepted and he has not been allowed to discharge his duty.
What is the offense?
The offense, my lord, what has happened in this case?
Answer the question.
Yes, my lord.
What is the offense?
Allegation that he has misbehaved a student of the school.
Misbehaved with the lady student?
Lady student. That was the allegation in the year 2018. On that ground, he was terminated from service. He approached my lords. Your lordship was the termination order. That order was challenged before in writ appeal. That was confirmed by my lord's order. Again, they went to Supreme Court. That order was confirmed. Thereafter, they started the departmental proceeding. When they started the departmental proceeding without supplying those documents, I filed a case before my lord.
And I directed sharing of the documents.
Yes, yes. Yeah. Then your lordship directed to give me the documents. They did not supply the documents. Again, they started the inquiry. When they started the inquiry, I filed an application to supply me the documents as per the direction by my lords. On that day, affair was lodged and I was arrested on the same day. And only short grievance why I have not placed all these facts, because on my joining, a clarification is called from the director. That is pending. If your lordship may direct that to
you have sought for clarification.
that
My lords,
Officer has to give the clarification.
I don't have a copy, my lords.
copy, ne?
Copy, give copy, one more copy.
Service say.
Whatever clarifications the lower officers seek at the hands of the higher, they have to give clarification. That will be end of the matter.
I'll serve copies.
Just show him.
Yeah.
Just show your paper.
Clarification to be.
It at page 34, mile.
Checkered history of this case need not be stated. First, suffice it to say that the petitioner was arrested on 12/9/2025 in connection with POCSO. The offense punishable under the provisions of POCSO Act. First, petitioner secured bail on 23/9/2025 and was enlarged from confinement. First, thereafter, he has made an application. Kindly be seated. How is your health now? Yesterday you were not well? No, other it was. His short grievance is that he is not being permitted to resume duty despite representation. First, he points out that the lower officials have sought for some clarification at the hands of higher, and the clarification has not yet been given, and therefore this court should intervene. Next one. Learned AGA Mr. Behura, on request appearing for the OPs, opposes the petition, contending that the petitioner is involved in a POCSO case, which is serious, and that he having misbehaved with a government student, it is not desirable that the court should grant interference. First, having so stated, he now agrees to instruct OP number. Who should give the clarification? OP number 2 to consider a request of lower officials for issuing clarification as to what should be done in the matter in a time-bound way. First of all, this needs to be done within a period of 2 weeks. First of all.
Let's grant some little more time because
for the clarification.
yes, my lord.
4 weeks. Okay. Petition with the above observation, petition is disclosed. All contentions kept open. Next. Item 13.
May I please, Lords?
Yes.
The petitioner, when working as a primary teacher, he was implicated in a criminal cases of offense under section 147, 148, 802, 436, 201, read with section 149 of Indian Penal Code. He has been convicted, imprisoned for life. Thereafter, in criminal appeal, he has been acquitted from all discharge. Now he has filed a representation to allow his consequential service benefits.
Why? You have not served during that period at all.
I am not served.
Then the Supreme Court said in 2 decisions that as a matter of rule, it cannot be claimed.
No, whatever period I have worked, that period of gratuity and other benefits has not been given. Because I have convicted in 2012.
Your representation is
Annexure 3.
So what is the legal position, Mr. Swain, where a person is convicted and conviction and sentence are set aside in appeal after years?
Yes.
What is how the period should be treated?
No disciplinary proceeding has
No disciplinary.
Yes. Then, my lord, if ultimately the disciplinary proceeding is held.
No, there is no disciplinary.
Yes, my lord, there is
There was a disciplinary.
yes, my lord. Annexure 3.
Huh?
Annexure 3 was
What they did. Then question is answered by the apex court.
yes, dismissed from service.
Huh.
Annexure 3, page 43. In the year 2017, he has been dismissed, suspended from the service. Thereafter, he has dismissed. That letter has not communicated.
You are dismissed now.
Yes, my lord.
Then unless dismissal order is set aside, how can you get the other benefits? It's a dismissal, not removal.
Dismissal.
If it is dismissal, everything goes.
This is a disqualification for future employment.
Future employment also, that apart. If it is a removal simpliciter,
Yes.
what you say is correct. Look into Samaraditya Pal and come back.
Yes, my lord.
2 weeks to come with more preparation. At the request of petitioner, counsel for petitioner. Yes.
May please. This matter is with regard to headmaster scale of pay. The issue already has been set at rest by this honorable court in case of Ramachandra Sahu versus State of Orissa, which was carried to the Honorable Appeals Court and affirmed. In a similar matter, your lordship has passed this order. Already I have
Show it to brother.
shot the copy to the copy.
Yes, yes.
So this may be considered, this case may be considered in the light of that Ramachandra Sahu and Baijanti Shaman.
Whatever order is passed to them.
Pardon?
Whatever order you have given, that will preach.
But in the sub item, there is another one item. In that case, representation is not there. But there is a clear recommendation by the DO
To make another representation.
No, then but once there is a recommendation,
Well,
why representation?
Yes,
Same
that-
order.
under Annexure 4, Your Lordship.
Good.
So the order may be slightly different in that line. Grateful, Your Lordship.
Next. Item 15. In second one, it is also open to the petitioner a fresh representation. One sentence you have to add. What?
Please, Manoj. Manoj, in this writ petition, Manoj, initially the petitioner approached this honorable court in WPC number 25146 of 23, Manoj, in which, Manoj, the coordinate bench of this honorable high.
RACP.
Yes, Manoj. In this, Manoj, the RACP was granted, Manoj. But actually the benefit is on the paper, Manoj. I have not received the benefits.
You let them consider your representation. Annexure 6.
my lord.
Manoj, I have already been allowed RACP. Manoj, kindly peruse.
That has to be released.
Yes, Manoj.
So you have sought for release of that one, na?
Yes, my lord. Annexure 5, page 28, my kindly peruse, my lord. Manoj, para 3, if I may please.
Hello. That money has not reached you. That benefit has not been given.
Yes, Manoj. It has been released, my lord. It has been allowed.
Sanctioned.
Yes, Manoj.
Not released.
No, Manoj.
For that you have given representation.
My lord.
Is it correct? There is benefits and
Yes, my lord.
Page 31, the
As such, in
representation.
compliance to order dated passed in WPC number 25146 of 23, filed by Ramachandra Bhanjar, retired assistant teacher, so and so school, the admissible benefits under RACP/MACP scheme similar to Ashok Kumar Mahapatra case is allowed. The date of entry into the cadre is dated 1/3/1983 and already availed second upgradation in terms.
you take notice, brother. I may impose cost in this. I'll impose cost rules and issue emergent notice. Mr. Behura is requested to accept notice for OPs. First half. A perusal of papers gives a prima facie impression that the orders of this court are not being followed. And citizens are being made to hover in the court hall unnecessarily. First off, it is a wasteful exercise. First off, however, no concrete opinion in this regard is stated at this stage. Next paragraph. The pendency of the matter will not come in the way of the subject representations being considered and relief being granted to the petitioner before the next date of hearing. First off, call this matter in the second week of December 2028. Fine. Since this is the second round of litigation.
Just one small thing. My lords, may kindly see the table, my lords. My lords, they have allowed me third RSB upgradation from date 1/3/2013. My lords, in the table, they have stated that financial benefit from 8/8/2013.
Not 1/3.
No, my lords.
Let us see.
My lords, grateful.
If they do something, this one. Just I have laid ground for imposing some more lakh rupees cost so that you will get more money. Okay? I have made the groundwork from. Yes.
Grateful, my lords.
Item 16.
My lord, the matter regarding rehab, regularization of service, my lord.
Covered by judgment.
My lord, your lord.
The Niranjana Das matter. It's covered, brother. Same order. Item 17.
17 में सॉल्व है लोकनाथ बेहरा केस है.
One sentence. Item 20.
21.
21. Give that. 20. Takes and other things you are saying.
Only when your lordship reflected on the implementation dated so and so under annexure 9. So that not reflected well.
It's not reflected. But anyway, it covers the matter also otherwise. Representation annexure 9 to be written.
Mile.
Oh.
Oblige versus.
Oblige versus.
Of course.
Item 18. May I please, my lords? I am in through online, my lord, and this short, my lord. This is the case, my lord. The father of the petitioner died sometime in 2013. He had made an application for rehabilitation appointment. He was selected for appointment against a junior clerk post, which is a Group C post, my lord. Kindly turn to Annexure 5, page 24. In 2009, he was provisionally selected, and the list is at page 29. What is it? Serial number? Pardon, my lord?
Modification of the date.
I can't follow, my lord.
No, my lord.
Sought for modification of the. You have to modify
Yes,
that.
yes. What happened, my lord? I was initially given appointment, proposed to be appointed against a junior clerk post. Now, after 5 years, 2019, it was done. But thereafter, no action was taken because of the new rule. Now, in Annexure 10, on 10/11/2015, they have offered me a post of peon. I'm a engineer, I'm a degree engineer, qualified, and I am able to work as a clerk, my lord, and the qualification. In 2009, they have assured that. That was I want modification.
Is it permissible under the rule?
Yes, my lord. Rule, because my case is to be considered as per the prevailing rule of 1990. Rule 5 says that the Group C post also they can be considered. That is why my case was considered way back in 2019. After this 2020 rule came, my lord, they have considered me only against a post of peon. Kindly turn to page Annexure 5, page 29.
Group D have been considered.
Yes, yes. DO have considered and placed me at serial number 39 of the select list for appointment as against the post of junior clerk.
Valid
Now
one.
the
See, the group D post. Subsequently, similar matters your lordship has issued notice.
You take notice that let us.
19 or 18.
No, for OPs. Okay.
Lord, this the last date of fixing the joining is 20th. So let this annexer 10 be lie over so that I may not be forced to join.
Let him join subject to result.
My lord, that is a class 4 post. He don't want to join. If I succeed, I will join, my lord.
Join. We are not saying it. Yes. It is open to the petitioner to join the post in person subject to outcome of the petition.
Item 19.
The petitioner appeared in the leave training reserve teacher matter, Your Lordship. That LTR matter already you have, Your Lordship, in many cases issued the notice. Yes, Lordship.
My lord, staff selection.
That.
No, it's a
1 and 2 you appear. Yes. Three panel council.
Panel councillors. No.
Who, Mr.
Sanjeev showing here it is.
Yes. Call Allah. Yes, next.
Subject to outcome of the repeats.
Yes, that is there in the order.
Item 20.
May I please, Your Lordship?
Yeah.
Well, this is a case of transfer. Your Lordship may kindly turn to annexure. Well, I have challenged the order of transfer on 3 grounds. My first ground is the order passed by the district education officer that is without jurisdiction. Because after 30th June 2025, the director is the competent authority.
Well, it's in the impugned order directors.
No, not the director. Your Lordship may kindly see. The order has been issued by the district education officer Puri, annexure 2.
Yes,
and Your Lordship may kindly see the guidelines.
The director education has also approved it.
Yes, well, duly approved.
No, well, at the so far as director, that approval is by the district level transfer committee. Your Lordship may kindly see the district level transfer committee as per that government notification at page 26. Page 26.
But more than a month has happened now.
Yes, that has happened. Your Lordship may kindly see Roman clause 12. Roman clause 12. Page 26 of that guidelines.
No, that I have seen you argued other days. Remember everything.
Yes.
But point
and
not that.
My second ground is well, at the
why there is more than about a month delay?
My lord.
In transfer matter,
yes.
Court said in Tangapadu that the grievance against the transfer should be worked out at the earliest point of time.
Yes, that is correct. My lord, here, my lord, they have indicated the grounds that on the ground of rationalization, I have been transferred. My lord, I was serving in a school where there are already 85 students. 85 students, enrollment is 85 in that school.
No, what is the explanation for the delay?
Delay, my lord, she has made a representation to the director.
Where is that?
That representation I have annexed.
Consider representation.
No. Annexure 5, page 37.
And my third ground is.
Anyway, representation is made.
Yes.
They should consider it.
And
petitioners' grievances against the transfer order dated 23/10/2025. First off, counsel for the petitioner urges several grounds seeking invalidation of the same. First off, learned DGA Mr. Behura, on request accepting notice for the OPs, in all fairness submits that since the petitioner has already made a representation at Annexure A5, he would instruct to OP number
2, Director Elementary
to look into the grievance of the petitioner as has been aired in the subject representation, keeping in view the extant transfer guidelines.
Yes.
First off, this is a happy thing to happen at this level. Next one, in the words of instances, 4 weeks.
My lord, till a decision is taken, your Lordship may say that at least.
Next.
Item 21 has been disposed of. Item 22.
In item 22,
Yeah.
the petitioner challenged the order of punishment
under Annex 17 on serious grounds, my lord. In a departmental proceeding initiated against him in 2013 under Annex 3, my lord, based on the preliminary inquiry submitted by 3 persons. It was hospitably turned to page 23, my lord.
Inquiry was held.
Preliminary inquiry was held. Thereafter, charges have been framed against the petition.
Correct.
The preliminary inquiry, the persons conducted the preliminary inquiry, 3 persons. Out of 3, 2 have been reflected as witnesses of the proceeding, my lord. And the said 2 persons have been appointed as inquiry officer as well as marshalling officer. So the entire proceeding, there is no other witnesses available, or there is no such witnesses have been produced before the inquiry, and the inquiry was completed by Honor Annex 6, stating therein that the stoppage of...
What was the allegation?
Allegation is that, my lord, at page number...
No, I'm asking the allegation, not page number.
Misbehavior to the girls borderer, gross negligence and mismanagement of school and hostel.
Misbehavior means with whom?
Girls borderers.
Touches,
girl students, man.
Girl students.
Yes.
And it touches their private parts, man.
Where it is nothing, man.
Yes, man. Page 22, man.
I am appearing on VC.
It will be safe with the hands off in the hands.
No, I have retired since 21.
It will come in regular course after 5-6 years. Yes, next.
Lordship, item 23, I am appearing on VC. In this case, the petitioner challenges the inaction of the opposite party number 1 to 4 in not handing over the possession of the minor daughter of the petitioner to him in pursuance to the order dated 15/4/2023 passed by the Member Child Welfare Committee Baleshwar, and in not carrying out the order dated 27/2023 passed by this Hon'Ble Court. At this moment, your Lordship kindly turn to Annexure 2 to the repetition page 15. Your Lordship kindly turn to page 20 towards last. Annexure 2, page 20, your Lordship, towards last.
What is this? This is the order of?
This order of the Child Welfare Committee, Baleshwar, your Lordship.
Are you from Delhi?
No, your Lordship.
You are from Bhubaneswar?
No, Cuttack.
Cuttack. Still you want to be on the online?
No, I am not well, your Lordship. I am suffering from fever, viral fever, so.
When will you be able to come before the court?
Lordship, Monday.
I'll call this matter on Monday.
The petition has been disposed of since 20th July 2023.
But the implementation has not happened. Who should implement the order?
Dispose of petition, therefore I...
Correct. The dispose of petition also it is there entitled to. Suppose if you do not comply with the order, what they should do? Contempt is one thing. Filing application is another. Why you are not implementing the order of the court? This is contention. Anyway, he is not here. Therefore, I am not granting relief to him. Call next week. Yes.
Item 24. May I please?
Yes.
So may I pray for more time? If, in this petition prays for modification of approval orders in pursuance to the matriculation certificate.
Approval orders. What approval orders?
Approval order in you also can have page 21. 21.
Actually, in this case, we have received the Parais Committee will file the counter matter.
It's calling the second week of January 5th. Next. Item 25.
Today I am filing objection to his intervention application.
I have filed an application for intervention, Your Lordship.
Look into the objections.
Just now I have received the
2 weeks.
2 weeks. Next week, Your Lordship.
Next week already,
because it's a case of transfer, Your Lordship.
He has no locus standi in the matter.
Your Lordship, I am the chairperson of the school managing committee, Your Lordship.
Well, it's school managing, it's a government school. My lord, the school managing committee has no role to play. And the term of the school managing committee has already been over.
It's over.
Yes.
I have to obtain instruction on this issue, Your Lordship. But at the time of filing of this,
filing already. But now,
I have to obtain instruction.
therefore,
So next.
Interim order
So
to
there is a stay already. The headmistress and the
You have no role to play.
item 26.
Also, I'm appealing for the petition. That's
Interim order to continue in both the cases.
Yes.
there are two
What's your locus standi? Your period has over and your application needs to be.
I will satisfy your lordship.
Yes. Item 26.
Matter 26. It's a matter relating to grant of UGC from the date of appointment probably. Lordship, I am to get ready, more ready, my lord. Fix a date.
I think this matter was placed before your lordship, that squarely covered by a judgment of a coordinate bench. Your lordship had directed me to supply a copy. I had supplied the copy to my husband.
Wants to look into it, come back. We'll have the second week of December.
I'll come, definitely I'll come.
10 week of December.
At the request of Mr. G. Yes.
Item 27 has been adjourned. Item 28.
Yes.
My lord, in this case, I have challenged the order passed by the State Education Tribunal under Annexure 6. Well, the findings of the tribunal is
Where were you before the tribunal?
for approval of my appointment and for release of grantee rate.
Approval of appointment and release of grantee.
Release of grantee rate. As per the grantee rate order of 2008. Because the college was notified to receive block grant from the state government in accordance with the grantee rate order of 2008. That is the admitted position. I have given the notification also.
On what ground relief is denied to you?
Well, relief has been denied to me on the ground that I have been appointed after the cut-off date, that is 1/6/1998, as enumerated in the grantee rate order of 2008. That is the only ground.
You are appointed after the cut-off date.
Cut-off date, that is 1/6/1998.
1/6/1998.
98. One phase order, that is the only ground.
How courts have treated this question?
My lord, yes. My lord, your lordship, may kindly see the grantee rate order of 2008 itself. That is page 443 of the education manual. 443. 443. The nomenclature of that grantee rate order is the Odisha non-government colleges, junior colleges and higher secondary schools grantee rate order 2008. This has been framed under section 7C4 of the Orissa Education Act. My lord, may kindly come to order or rule 4. Eligibility criteria for consideration for block grant. 4.1. At page 445.
Fine.
Yes.
Eligibility criteria.
For consideration for block grant. The educational institutions described in para 3, which have been established with recognition of government and affiliation of the council or the universities as the case may be, on or before the 1st June 1998, this cut-off date has been, my lord, 1/6/1998 in respect of educationally advanced districts, on or before the 1st June 2000 in respect of educationally backward district, and women's educational institutions established
for block grant.
Yes, on or before the 1st June 2000 in both educationally advanced districts and educationally backward districts are eligible for block grant to be determined in the manner specified in paragraph 16.
What is meant by that?
My lord, those institutions which are in advanced areas, if the institution has got recognition and affiliation prior to 1/6/1998. So far as backward area is concerned, that is 1/6/2000. And women's colleges?
Other, this one, it is 1/6/1998.
1/6/1998. So here, if the institution has got recognition prior to 1/6/1998, if it is located in an advanced area, then that becomes eligible to receive granting aid from the state government as per the granting aid order of 2008, subject to fulfillment of other conditions. Admittedly, our institution has got recognition
before the cutoff
date, and it has been notified to receive.
Cutoff date is not with reference to your appointment.
This is only
with reference to
recognition and affiliation. Recognition and affiliation. And I have also annexed the
courts have viewed this question.
My lord,
my brothers have viewed this question.
My lord, possibly this question has not been dealt with. And your lordship may kindly see, I have given
the dates of appointment are irrelevant.
Yes.
What is to be seen is section 4, the focal point being the
date of recognition. Date of recognition and affiliation. And here, your lordship may kindly see, I have annexed the recognition order.
No dispute about that.
No dispute about that.
What do you say, G? It's the parameters of both into dates of appointment of the candidate.
It is.
Candidates come and go.
My lord, paragraph 3, which has been, is applicable to eligible educational institutions. It is for institutions. The following non-government educational institutions shall only be eligible for consideration of block grant for being notified as added educational institution under.
Where are you reading?
Paragraph 3, just before.
Eligible educational institution.
My lord.
Correct.
The higher secondary schools or colleges, junior colleges recognized by the government or affiliated to the council.
They fit into these parameters.
My lord. Yes.
He is putting forth.
My lord, so far as 4 is concerned.
What?
4 is concerned, my lord. The tribunal has said, my lord. Lordship may kindly have a look to the
tribunal's order.
Tribunal's order at page 22 of the brief. Hard London Council for the. Can I place, my lord?
Yeah, I have seen that.
My lord.
All order.
Yes. Who is working as a lecturer in political science in so-and-so college in the district of Jagatsinghpur in this application under 24B of the Education Act.
From
the order.
He is appointed after, that is 9/10/2003. That is
the cut-off date. He was appointed on 9/10/2003, which was after the cut-off date of 1/6/98.
Now, where is the cut-off date?
My lord, here is the cut-off date, my lord. The institution have established with recognition of government, affiliation to the council or the universities as the case may be, on or before 1st June of 98 in respect of educationally advanced so-and-so. My lord, this is the cut-off date.
Where?
1/6.
It does not speak of appointment at all.
The educational institution is to be considered.
Establishment of the education institution, affiliation and sanction are spoken of.
My lord.
You are reading section rule 4.
Yes.
You are extending it to date of appointments also.
Okay, that is that of, my lord.
How?
The educational, I am placing thereafter, my lord. The educational institution to be considered for block grant in accordance with this order shall have received recognition, affiliation for course. My lord, this is so far as the institutions are concerned. That is the cut-off date by which the appointments were made. Once the institution is added, my lord, the managing committee cannot appoint its employees in terms of 74 rules, my lord.
74?
Yes.
Which is that rule? That is not the ground he has stated.
That is not the ground. That notification was made in 2011.
That is not the ground he has taken here. But the added institutions 74 rule says, my lord, once the institution is added, management seizes its rights to appoint the employees. It is their teaching employees, my lord.
No, I'm processing your sentence.
My lord, your lordship may kindly see the
One second.
Yes, sir. Please.
Which rule you are referring to?
74 rules, my lord.
Read.
I'm coming to that.
there is a prohibition for appointment itself.
Yeah, management cannot appoint. If you will appoint, then it will be for a particular period, not beyond that, 976.
Which is that rule?
Nine seven six.
976 page.
976.
My lord, it said Orissa Education Recruitment and Conditions of Service Teachers and members of the staff of aided educational
Right, so-
institution 74. Rule 8.
Which rule?
Rule 8. Chapter 2. Rule 2. Your lordship may kindly have a look. Notwithstanding anything contrary in these rules, it shall not be necessary to apply or submit any appointment made by the managing committee of the governing body to the selection board. A. If the appointment is made on ad hoc basis for a period not exceeding 3 months. B. The vacancy in a post carrying higher scale of pay is filled up with prior approval of the government in the case of college and concerned director in the case of institution other than the college by the employee of the same institution who possesses the prescribed qualification. So prior approval has not been taken from the appropriate authority by the
Relating to promotion, to the appointment to a post carrying higher scale of pay.
My lord, no, it is not. 8 to B is different. But the appointment is made on ad hoc basis for a period not exceeding 3 months. Notwithstanding containing, this one is bars.
For the
managing committee cannot appoint any person.
Approval becomes necessary.
Yes, higher authorities of the director. The management cannot appoint its employees without prior approval of the director.
My lord.
Even if you will make, then it is for a particular period, not indefinitely.
How were you appointed? When were you appointed?
My lord, I was initially appointed on 18/10/2000.
18/10/2000.
Against +3 wing of that college.
Within the selection took place?
Yes, selection. My lord, selection was there.
Members of the selection body? When the selection took place, who constituted the selection body?
The management has given me appointment.
No, question is not that.
Yes.
Kindly come to Rule 8.
Rule 8.
Rule 8, 2 and 3.
3.
Speak of the selection body to be constituted in a particular way.
My lord, my first submission before your lordship is, so far as 74 rules is concerned, this is applicable for aided institutions.
Is it?
My lord, yes.
Can you say that your institution is not an aided institution?
No, let me submit.
My lord, yes, if it is not added, then I have got nothing to say.
No, let me submit. My lord, my appointment was made during the unaided period, and the institution was notified to receive block grant as per notification dated 8th April 2011. Your Lordship may kindly see my FAO. Yes, Annexure 15. Annexure 3 series at page 15. So how 74 rules is applicable to me? Page 15. The notification dated 8th April 2011 in pursuance of the powers conferred by Clause B of Section 3 of Orissa Education Act 69. Read with Para 7 of Orissa non-government colleges, junior colleges or higher secondary schools. Granting Aid Order 2008. The state government do hereby notify Siddha Varango College of Education and Technology, Junior Purnanga, in the district of Jagat Singhpur as aided educational institution to receive block grant in terms of
becomes aided institution with effect from
8/11/2011. So after 8 April 2011, the 74 rules is applicable. Since my appointment was made prior to the notification, and the law is well settled by the full bench judgment of this Honorable Court, that only from the date of notification, the institution will acquire the status of an aided institution, even if granting aid is made available to that institution from a retrospective date.
So date of notification is the criteria.
Is the criteria, because this notification was made in terms of Section 3B of the Orissa Education Act. Your Lordship may kindly see Section 3B of the Orissa Education Act.
It became notified institute, aided institution.
Aided institution in terms of Section 3B. 3B. Your Lordship may kindly see Section 3B of the Orissa Education Act, which defines aided educational institution. 3B, the definition chapter, page 115. Page 115. My lord, got it? Page 115. 150. My lord, may kindly listen. Section 3B. Aided educational institution means private educational institution which is eligible to and is receiving granting aid from the state government and includes this is the second part, and includes an educational institution which has been notified by the state government to receive granting aid. So here notification was made in April 2011. My appointment was made prior to that date.
So as on that date you were appointed.
Yes.
These rules were not applicable.
These rules were not applicable.
74 rules were not
74 rules were not applicable. So application of Rule 8 does not apply to my case. And my alternative submission before your lordship is, so far as Rule 8(2)A is concerned, it relates to ad hoc appointment. So far as 8(2)B is concerned, it relates to appointment to a post carrying higher scale of pay.
That question will not arise.
That question will not arise. And here, therefore, the learned tribunal has held that since I was appointed prior to the cut-off date, after cut-off date, 1/6/1998.
These things that you could have raised it before the tribunal.
A tribunal.
Sir, but the facts are available here. Where have you pleaded the rest of the things? The tribunal proceedings.
Tribunal, my lord, unless and until the matters were placed before the tribunal, how the tribunal will deal with all the matters.
No, when what all where is the
tribunal's order is very short.
Appeal paper.
Yes.
Appeal.
Will set aside this order and remand the matter for consideration of fresh hearing. Take up for that. That appeal.
So that yes. Then your lordship is settled, sir.
With the time bound way, because so much time is spent now. Kindly be seated.
Yes.
This appeal under section 27C it is 24C.
24C.
24C of the Orissa Education Act 1969 seeks to call in question the order dated 10 June 2019, whereby appellant, you call is a petitioner or appellant here?
Appellant.
Appellant's OJA case number.
GIA case number. GIA case number.
GIA case number 237 of 2016 has been negative. And as a consequence, his prayer for grant of approval and consequent release of block grant has been negative. First of all. The second paragraph of the appeal, the impugned order being relevant, is reproduced for ease of reference. Next paragraph. Learned counsel appearing for the appellant submits that the tribunal grossly erred in taking the date of appointment of his client, namely 9/10/2003, as relevant for consideration of the prayer, when what is relevant is the cutoff date 1/6/1998 fixed under Rule 4
of the Granting Aid Order of 2008.
Of Granting Aid Order of 2008. In other words, he argues that the date of appointment is irrelevant for considering the claim of the appointee for approval of granting aid, approval and release of granting aid. Therefore, he seeks invalidation of the impugned order. Learned AGA, Mr. G, appearing for the OPs, vehemently resist the appeal, contending that in view of the 1974 rules, more particularly Rule A, the appointment of the appellant would not have been is at all, and therefore the question of granting approval, the release of granting aid would not arise. First one. In reply, learned counsel for the appellant submits that the institution itself having been notified for grant with the effect from
8/4/2011.
4/2011. And the appointment of his client preceding such notification, the 1974 rules would stand miles away from the case. First one. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, this court is inclined to grant indulgence as under and for the indulgence in the matter as under and for the following reasons. First one. A. There is a force in the submission of learned counsel for the appellant that the application of 1974 rules is only to the aided institutions, and that as on the date his client was appointed, the institution was not aided. First, he is right in telling the court that the rigors and restrictions enacted in Rule 8 2 of 1974 rules may not be applicable to the case of appellant person. Next panel. Is a contention that Rule 4 of 2008 rules contemplates the grant of approval for affiliation.
Recognition. Recognition and affiliation.
Recognition and approval.
Affiliation.
To the institution in question of the kind before 1/6/1998. And that the question of date of appointment of the teachers has nothing to do with the parameters of this project.
Yes.
That being said, the relevant factors such as the date of notification of the granting aid to the institution in question and the nature of appointment of the appellant to the post in question, or the matters of facts which the appellant has to plead and prove before the tribunal itself, if necessary, by amending his appeal memo.
Yes.
That course cannot be adopted here. First, next one. In the above circumstances, this appeal succeeds in part. The impugned order having been set at naught, matter is remitted to the portals of the Orissa Education Tribunal at Bhubaneswar for consideration afresh within an outer limit of 6 months. 6 months, because years have gone already.
Yes.
All contentions of the parties are kept open.
Yes.
Kept open. Okay.
Mention item note 24 interim order is there. If the interim order may continue till
24.
24
interim order.
I said.
Which is that rule 4 of 2008 phase number?
2008 443.
443. 443. That is 2008 drafting. And 74 rules. They are at 976.
976.
Yes.
Item 29.
29.
It's one or one.
You want some time in the second week of January 2025 at the request of. Yes.
Item 30.
Yes. Yes.
But this is a case. This case has got a thicker history. My Lord, although the case is covered by the judgment of this Honorable Court, in Balaji Sahu's case, the the appellant was appointed as a classical teacher on 31/3/1999.
Make a statement.
Yes.
Make the statement.
My Lord, the appellant was appointed as a classical teacher on 31/3/1999. But some dates are there. May I prepare a date chart?
Date chart. Date chart to be published by the appellant.
Sir, it is
date chart.
First of calls in second week of January. Yes.
Item 31.
31.
31?
I'm on a blank, 5569. It's for number 556 of 2024, first month.
So far as item 31 is concerned, my lord, Das has made a request to me that let it be passed over. My lord, may take up this matter after lunch.
Some documents here we have given.
Item 32?
Yes. Item 32, the order of the State Education Tribunal is under challenge at Annexure 5. And the prayer for release of granting aid
Sir, may I kindly have a look to.
May make it clear. I make it clear, madam. Only point of involved, there is no fact.
ନା ମୁଁ କିଛି କହୁନି ଆପଣଙ୍କୁ ଟିକେ ଖାଲି ମୁଁ ଖାଲି କୋର୍ଟକୁ ନୋଟିସକୁ ନେଇ ଆସୁଛି page 33 the ordering portion of the tribunal's order, my lord. Unless last paragraph, my lord, school as institution notified by the 99 order 2008 the question of approving the appointment of the teaching non-teaching staff under the order doesn't rise at all, my lord.
Next, my lord. That is important.
For the purpose of
re-notify the school and the granting in order to
whether you are
taking the date of please start.
ନା ମୁଁ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ କହୁନି ମୁଁ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ କହୁନି please. Tribunal is there to decide whether the institution will receive granting aid or not. It is there for only. I want that he has not, because he has not decided anything, let it be decided.
Remanded for
my lord. Yes, exactly. That is what I am suggesting. I do not know what he will say.
My lord, but the last three lines, my lord, is the ground they have what my lord and brother pointed. This tribunal has no jurisdiction.
No, that may not be correct.
That may not be.
That may not be correct.
That is
for that.
Therefore, my humble submission before Lordship is 24B. Let it be clarified so that other matter will be saved, not being disputed.
It is there. No clarification.
Because the 24B
Harjit course case. This course case, it has been decided that the tribunal is to adjudicate on merit, not by remanding to the.
No, that is not done. This point is not involved here. Where in the Harjit Kaur's case, what has happened? The tribunal again directed remitting back the matter to the government to be considered. That's why Harjit Kaur case says, no, 24B has is a substantive provision and tribunal has to adjudicate the issues. Here is a point, your lordship will kindly appreciate.
It has to adjudicate on merit.
But here what they have done, madam, they have rejected saying that the tribunal has no jurisdiction, madam.
That may not be
to direct the notification of the institution. Therefore,
I will say that both sides agree.
Yes.
That the tribunal has to decide the matter on merits in the light of the decision. Harjit Kaur.
This is a point of law to clarify. Your lordship, only that to notify, directing to notify is not coming within the jurisdiction. That is the misconceived idea of the tribunal. My humble submission before lordship is 24V.
Whether notification is right.
It is inclusive within the power, madam.
Agreed.
That is to be clarified, madam. Because 24B, that says so. Eligibility, entitlement, payment, non-payment. And the language is all dispute and differences must be adjudicated relating to eligibility, entitlement, payment, and non-payment of granting. Therefore, it covers the issue of notification.
If you permit me, I will pass an order. Right.
This is the language of section 24B.
24B is as clear as gazetting.
Yes.
Exhaustive. All disputes.
All disputes and differences. Language is
entitlement,
yes,
payment,
and difference.
Everything. Language is clear. 24B.
Oh, it is there.
Your Lordship, kindly turn to the
Page 159.
Yes, 159, 24B. May I read, my lord?
Yes.
The tribunal shall have jurisdiction, power and authority to adjudicate all disputes and differences, between so and so, last line, my lord, relating to or connected with the eligibility, entitlement, payment or payment of grant. Therefore, the directing to notification comes within the sweep of the, it is inclusive, your doctrine of
Which decision decided that the expression dispute and difference by Krishna Iyer and GL Ocha take out under the ID Act?
Yes, Industrial Dispute Act.
They have identified the O.P. Malhotra has given a list of judgments. See that disputes and differences. Supreme Court on words and phrases. Ask Surendra Malik. If industry is industry disputes and Truly is going back, fearing that I may put question to him.
I'm just may associate to whether you have got it.
The object of court proceeding is not only adjudication, but upgrading the bar also.
Yes.
Upgrading the judges also.
Yes.
We should upgrade ourselves with your assistance. Otherwise, proceedings will be sterile and nobody will look at it. Dispute and difference is there. There is a Supreme Court judgment that book is not updated at all. Dispute is there. Difference is also there. Yes, 2K. Industrial dispute means any dispute or difference between the employers and employee. This is interpreted by Justice J.L. Oja and Justice Krishna Iyer. That book is not updated. The books are very substantive, all not full covered. Give that. Difference. Difference will go before the court.
Yes.
That shows the gamut.
That is the gamut. That is the gamut.
The dispute, all right. That is BWSSB.
The tribunal says that disputes relating to aided institution can only be adjudicated.
Updating. 2005 Supreme Court. Yeah, I did not register your presence at all. You should prove your presence by saying something. Yes, what the court says. Read.
The inclusion of the Act shows that an industrial dispute is between an employer and employee, or between employer and workers, or between workers and
Then how it is explained?
and it includes employment or non-employment, or the term of the employment, or with the condition of favor of any person.
2005? You see? Yes. Right. Please be seated. Kindly sit down. Yes. Go to the appeal. Appellants GIA case number 106 of 2024 has been negatived by the tribunal with the following observation. Unless the school and an institution gets notified. So and so up to end of next paragraph. Learned counsel for the petitioner, Mr. G, kindly be seated. Learned counsel for the appellant ultimately argues that the impugned order suffers from the vice of self-negation of power, and therefore interference of this court in appeal under 24C of the Act is eminently warranted. No, C is here. He draws attention of the court to the text of section 24 capital B 1. And 2. Text of 24B 1 and 2 of the Act in support of his contention that the expanse of this provision is very wide, and therefore the tribunal could not have rejected the appeal on the ground mentioned in the impugned Act. First, learned AGA Mr. G, for some time having opposed the appeal, now agrees with the contention, the submission of learned counsel for the appellant so far as legal conspectus is concerned. First, both the sides submit that the parameters of section 24B, clauses, subsections 1 and 2 of 24B, be made clear so that similar cases do not unnecessarily throng the portals of this court. First of all, there is force in this submission. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, this court is inclined to grant indulgence in the matter by way of setting aside the impugned order and remitting the matter back to the portals of the tribunal, keeping in view the wide expanse of subsections 1 and 2 of section 24B of the 1969 Act. First of all, for each of reference, the said provisions are reproduced below. Next point. Very importantly, the state legislature has employed the expression all disputes and differences, inverted commas, in subsection 1 of the section. In one subsection 1. First one. Further, these disputes and differences are post-fixed by other expression in words relating to or connected with the eligibility, entitlement, payment or non-payment of grant in aid, inwards coming. Textually speaking, the width of this section is more than that of section 2K of the Industrial Disputes Act, which reads as Industrial Disputes Act 1947, which reads as first. The expense of this provision is discussed by the Apex Court in AR 2005 SC 998-998. First one. Next paragraph. The establishment of the statutory tribunal for adjudication of all disputes and differences arising between the managing committee, the governing body of institution and any teacher or employee of such institution or the state government or any officer or authority of said government. That is all. What is the section? First, it is the state government or its officer or authority that decide notifying of the grant in aid. Obviously, whether such notification is rightly issued with respect to effective date, quantum, and the like are also the subject matters of section 24B. First one, the tribunal cannot say that the appeal is not maintainable.
My Lord, can I interrupt? The law says, my Lord, the 24B says, it is meant for the aided educational institutions.
Suppose aid is rejected. You mean to say he does not have right?
My Lord, here it is, let's say, may kindly have a look to page 33 of the order. And the point of my Lord.
Impugned order is put in challenge here.
My Lord, your Lordship is right. What he has written, applicants being the teaching and non-teaching staff of so-and-so school government school insert, have sought for a direction to the state opposite parties to declare their post to be eligible for receiving block grant in terms of granted order. 2008.
Section 3B.
My lord, unless and until
it was there perhaps.
My lord, unless and until it is declared or notified to receive grant in aid, it cannot be.
That will kill the section.
No.
That will kill the section.
Yes, that is what section 3B, your lordship may kindly have a look again.
Yeah.
I'm placing that, man.
No, Mr. G, I'm just asking. You mean to say a private institution cannot approach a company?
Approach here for the purpose of granting aid.
No, even for that.
No.
Kindly come to section 24B.
No, it cannot.
Private institution, any teacher of such institution of the state government or any officer authority of the state government relating to connected with the eligibility, entitlement, payment, non-payment of grant in name.
Yes.
It's very wide. It's very wide.
Unless and until it is declared added.
No.
Cannot be.
No.
That is my submission, your lordship.
Madam, one thing. I think without looking to the granting it order under which I have prayed for the relief, sought for the relief, that granting it order 2008 itself, para 7 says, married, notification conferring aided status. A non-government educational institution found eligible under para 4 shall be notified. It is an obligation under the government, casts upon the government. Therefore, read with 24 we read with this. Yes, that submission whether fulfilled or not, it is tribunal to adjudicate. Company will say, I have no
unless and until you are declared to receive or notified to receive granting aid.
No, if even says,
no,
I am not declared and I am not notified, therefore give this.
Yes.
You mean to say for that where he should go?
My lord, your lordship may kindly then see section 3B, section 3B of the act.
Eight answer. Seventh answer.
Section 3B.
That defines aided institution.
Yes. Yes.
That notification is necessary.
Means aided educational institution means private educational institution which is eligible to and is receiving grant in aid from the state government and includes an yes.
So come to educational institution.
Yes. Here, my lord, here your lordship may kindly have a look. 24B. The tribunal shall have jurisdiction power.
Your private educational institution.
All the differences between managing
section itself says.
Yes. The governing body
not
of any alone. And any teacher or employee of such institution or the state government or any officer or authority of the state government relating to connected. So, my lord, unless and until
educational institution.
Any private educational institution.
Unless and until
aided.
My lord, it is meant for aided.
No. Otherwise, they would have said that one.
Well, a private educational institution has been defined under section 3O. Lordship may kindly come
which is not aided.
Which is not aided.
That's all.
Private educational institution means any educational institution which is not established and managed by government of Odisha, the union government or government of any other state. That is the, my lord, section 3O.
Not even the question of aid and other things also will not arise.
Yes.
Going by that definition.
That is the definition.
This is my contention, your lordship.
No, I will consider, but I will say the word rejected.
Yes. And about 7 we considered also. Because the order casts an obligation, it is statutory, framed under section 7C. Shall be notified. That is for the purpose of
merits of the matter.
Merits of the matter subject to fulfillment of certain conditions.
Of this one.
Yes. Then the scope criteria is recognition, affiliation, and other criteria, it is to be scrutinized. Therefore, all formalities, that covers the all connected issues, related issues. Therefore, related issues is
whether what all issues will be covered. Just enlist so that I will enlist them here.
Your lordship will find. Your lordship may kindly take note of the definition of section 3O at page 116.
3O. Private educational institution.
Yes. Private educational institution means any educational institution which is not established and managed by government of Odisha, the union government or government of any other state.
No, we need not go that much because section itself says 24.
Yes.
24
Private
itself says private is
yes, not aided. It covers all.
Next part. The very big submission of learned Mr. G that the provisions of section 24B are attracted only in the case of aided institutions is very difficult to agree with. First, the very text of subsection 1 uses the expression, employs the expression private educational institutions. First, countenancing G's contention would be rendering the expression private educational institution employed in the section OTOs, and that cannot be done by the court. First, the apex court in a series of cases has held that every word employed in a provision of law has to be given due importance and meaning without rendering any of them RTOs. Why? So get which is that the statute should be read as a whole. Every word should be given meaning. It's just old judgment. Justice Vivian Bose's judgment is there. Go to G.P. Singh's interpretation of statutes. First, more is not necessary to specify. First, this apart, a coordinate bench or division bench it is, Mr. Swain, which you said.
Well, that is single bench.
A coordinate bench of this court in
2014.
Go to that judgment. A coordinate Harjit Kaur.
2000. That reference has been.
A coordinate bench, it was there already. A coordinate bench of this court in Harjit Kaur versus State of Punjab. Oh no.
No. Harjit Kaur, our state. Okay. Consider. Harjit Kaur versus State of Orissa.
State of Orissa. Just give
reference.
Yes. This was the state.
So it was Babu.
Harjit Kaur versus
AR 2014.
year 2014. In Orissa 198.
Yes.
Has observed as that. First, in the above circumstances, the appeal is allowed and the impugned order is set at naught. First of all, matter is remitted to the tribunal for consideration afresh on merits within an outer limit of 6 months. Which was the appeal is of which year? Appeal is of 24, within a period of 1 year. Within an outer limit of 1. All conditions are kept. Thank you. I'll make this judgment reportable. Yes.
It's a constitutional bench judgment that the word should not be as your lordship observed. But must not be OTS. Then other judgment, but I have not brought. That is why I could not. That the citation is 1868 Supreme Court, online 40. Page 40, that says tribunal must address all connected and ancillary questions. And also other judgments are there. 2008 in Supreme Court, all connected matters to be to provide complete relief to the party.
That will be very vaguely stating the thing. I have stated all.
Yes, madam.
But the section itself is clear.
Yes, ma'am.
Section itself go for interpretation.
Section itself is clear.
Get the GP Singh also. Yes.
This particular, the board matter which I mentioned, my friend is here.
Yes.
That to the.
Yes, Mr. Patnaik.
My lords,
Whether relief can be granted to him according to.
no, my lords, the development is, since I had put a query to the instructions received from my client, the thing has prevailed over them and it has gone in favor of my learned brother's client. The file has been sent to the competent authority at the headquarters for necessary approval. So in that view of the matter, my instruction says I should be given time till 28th at least. By that time, the whole thing should.
But the cutoff date will be.
No, in that case, what I am placing is, since it may go in favor of the so they will be allowed, because there are similar matters in Madras High Court and Delhi High Court. So there.
Call this matter on 28. 28. Okay. Call this matter on 28 at the request of the senior panel person who submits that some positive development is taking at the hands of board. The petitioners need not have the apprehension about the cutoff date being getting expired. Yes, very safe.
Item 33.
Item 33, it says status appeal, my lord. Challenging the order of the trust.
Notice was issued.
The appeal limitation.
33.
This was not issued. They have appeared in this case. Notice it.
Yeah.
Theater, they have appeared.
You appear for OP.
For the respondent, sir.
Correspondent.
Your Lordship, the counsel is actually on his legs right now and he couldn't appear. So we were.
Voice is not audible. See my voice.
Actually, I have a cold, sir.
Your cold.
Says that her senior is on legs in different court.
Okay.
So
we're asking for a short adjournment.
First week of January?
Yes.
Yes, Your Lordship.
Notice was issued. Notice was issued in this case.
There is an order. Yes.
Grateful, Your Lordship.
Item 34.
May I please? Here the fact of the case, the petitioner by appellant, that the appellant was appointed as a lecturer in Darshan.
What was your?
My case.
Why are you here?
I was appointed in 2008. Since my name was not recommended, and by manipulating the records by the ex-secretary and ex-member of the governing body, some other persons were named by tampering the records. I filed a complaint before the opposite party 1 and 2, director and the department. They make an inquiry. In between, the institution was declared an aided institution. They made an inquiry and come to a conclusion that the petitioner is also entitled to get the benefit, but some wrong has been committed, manipulation has been committed. So therefore, the granting of is to be withheld. The opposite parties, they challenged the order of the inquiry before the law and tribunal. I filed an application for intervention since an inquiry was made on behalf of some persons, including the petitioner, and in inquiry report, my name was found placed that I was genuinely appointed. My name was replaced by a persons, those who are working in a different institution, but they were brought back to the institution and their name was inserted to get granting it. The tribunal rejected my application.
Application for implement.
Implement. And finally matter was disposed of and state has challenged in the subsequent FAO, my lord. We just track to that. This entire report of the state government in my favor that all the documents should be manipulated. But that was not considered by the tribunal, my lord. That is the whole my case, my lord. And so far as the subsequent
State also filed an appeal challenging the order. There.
Who is your opponent?
Notice not issued.
Notice not issued.
Issue emergent notice. In both the matters.
Yes. Both the matters. Other one.
Final.
I'm challenging the final order passed.
Correct.
There they have
Challenging rejection of
Yes. Inquiry report.
In both the case, notice has not been issued.
Yes, emergency.
It's a state of notice was not issued, my lord.
I have entered my appearance for the respondent number 1.
Issue notice.
I will already respond.
Respondent number
1.
Other respondents?
The governing body. The governing body is the respondent 2.
You are the only respondent.
I am the only contesting respondent.
Issue emergent notice to OP number 30, respondent number 2.
Item 36.
36, my lord. In that case, your lordship, the similar issues has passed issued notice.
Issued notice already. Yes. Issued notice. Connected matter or similar?
Similar matters, same issue.
Can we call along with that?
Yes, yes, ma'am.
Call this matter along with. Yes.
Item 37.
तो एटा भी नोटिस तो जाइने ना
No notice. 38 days delay.
38 days delay अछि notice
No notice.
notice जाओ
Notice. Yes.
If 3 my lord,
Notice.
the private opposite party matter.
Like that is right. There is some procedure in your court which I do not understand. It's not there in the rule at all. Yes.
OP number 3 my by speed post. OP number 3 by speed post.
OP number 3.
Man, respond number 3.
1 and 2 will take
Notify the state.
Notice for 1 and 2. Emergent notice to OP number 3.
Item 38.
Item 38, I humbly suggest my lordship may give me some time. It has come to me. See, wait, 3 to 4 days time may be given so that.
Next week you do that. Something has to be done.
I'm trying. Let me see.
Yes, sir. Appealing for opposite party number 1 to 3 ASI minor. Your lordship last occasion directed to take the enter files with the pen drive minor.
You request your friends to be silent because they will not obey. Yes.
Last occasion your lordship directed to take enter file as the file is not available with me minor.
Not available with you.
Minor. Therefore your lordship directed to take it through the pen drive minor. But there is no written orders. Therefore they did give.
Register to furnish pen drive copy to learned counsel appearing for OP respondent.
1 to 3 minor.
1 to 3.
ASI. ASI.
My lord, here my humble submission is, my lord. Here the contempt petitioner is not there, my lord. I am in the tide of matter, my lord. Last occasion, the contempt petitioner mentioned that that's why it was listed, my lord. But he had not brought you to the notice, my lord. In the meantime, they have approached the Honorable Apex Court and there was order.
Stay is granted.
Yes, my lord. The writ appeal that was disposed of, my lord. This contempt first matter arises out of writ appeal number 81, my lord. And here this SLP also arises of that final order of that, my lord. So he had not bring it to the notice of this honorable court, my lord. And today he is not present here.
Then we will dispose of this with liberty to revise.
It is only the contempt, my lord, not my matters or tide of matters, my lord.
No, only contempt matter.
Bow down, my lord.
Will be disposed of with liberty to revive after the disposal.
Because during pendency of the writ appeal, that contempt has been filed, my lord.
That's what.
And this final order has been passed, and they have also approached he should brought it to the notice of this honorable.
But he may not be aware,
Yes.
aware of that.
Last occasion also he mentioned that that's why these three matters are tied up. On the month of October, this he had this matter was listed, content was listed
On 28th,
of the January 2025 month. But after checking the order sheet, I came to know that on pension, that was the,
But that counsel is also not here today.
that he had engaged a senior advocate, my lord, and the
Both are not here. Then let them come. We
Yes,
cannot
yes,
pass
my lord,
them
on
Call
other
in the
date, another
first week of January 2021. First, the interim order granted by the FX court in SLP number 4242 of 2025 on 21/2/2025 is taken on record. First time.
published, my lord.
Next.
Item 39.
Item 39, stated that matter relates to the in portions to direction of this honorable court in anticipatory bail granted 5 lakh to deposited.
That is not returned.
That is only
When you are acquitted in the matter. Not acquitted. You are not set up for trial at all.
That is the matter only that the business
Lordship permits, Lords, I am Sangram Das. I am the standing counsel of Vigilance Lords. I appear in this case for the opposite respondent 2 and 3. 2 is the Director Orissa Vigilance and the 3 is the SP Vigilance Cuttack Notes. Lords, with regard to the petitioner prayer, which is pinned with opposite partner 4, who has kept the money as a condition precedence for granting that anticipatory bail, Lords. But 2 lines in this case is important, my lords. 4 accused persons are involved, including the petitioner, in misappropriation of fertilizer stock, my lords, to the tune of 44 lakhs 11,500. In the FIR, my lords, the petition name is there, my lords. After conclusion of the investigation, my lord, the charge sheet was filed against 1 person, not against the petition has not been charged yet, my lords. And for that reason, my lords, that has been clarified in page 20, annexure 4, my lords. You will also see the annexure 4, page 20, is issued by the Superintendent of Police Vigilance Cuttack.
Yes, yesterday he read.
And this is a genuine one, lords. This is the position. Petitioner has not been charged yet, lords. And with regard to his grievance for not responding that 5 lakh rupees he deposited pursuant to this order of the court in granting the anticipatory bail, lord, that is a matter between the petitioner and the opposite partner 4.
Where is OP number 2? Counsel for OP.
OP number for notice has been issued and it is sufficient also, but that did not appear. Inspector, notice.
40 serial number 39. Petitioner has made the following prayer. First one, learned counsel for the petitioner submits that as many as 4 persons, including his client, were named in the FIR, which eventually resulted into his petitioner seeking anticipatory bail in which is that case number?
Page 18.
Case number.
7133.
What is that?
ABLAP, anticipatory bail application number 7133 of 2017.
ABLAPL number 7133 of 2017. Disposed of by a coordinate bench of this court while order dated 23/4/2018, admitting the petitioner to anticipatory bail, subject to the condition that he should deposit a sum of ₹5 lakh with
Before opposite number 4.
OP number 4.
Annex to 3 is the receipt.
First one, counsel for the petitioner submits that his wife, having deposited the said amount as a condition of anticipatory bail, is entitled to the refund in as much as after the investigation, the final report has been filed by the jurisdictional police, wherein petitioner does name of the petitioner does not figure at all.
Not charge sheeted.
Therefore, in other words, petitioner is not charge sheeted. First. Next paragraph. Learned senior panel counsel appearing for OP number.
Standing Counsel Vigilance, Sangram Das.
Counsel appearing for OP
For office for number 2 and 3, my lords.
OP numbers 2 and 3 very fairly submits that the version of the petitioner is true. However, the answering OP is, or answering party is OP number 4. First, OP number 4, despite service of notice, has chosen to remain unrepresented, and that would not come in the way of this worthy cause being adjudged by this court on merits. Next paragraph. Having heard learned counsel for the petitioner and learned standing
counsel Sangram Das.
So this court is inclined to grant indulgence in the matter in as much as petitioner had made the deposit of a sum of rupees 5 lakh with the OP number 4 as a precondition for securing the anticipatory bill in the event he was apprehended. First, now the petitioner, having not been named in the final report for charge sheet, this amount needs to be refunded to him. First, otherwise, that would be forfeiture of private citizens' money without authority of law. First, this contravenes the provisions of Article 300 capital A of the Constitution of India as expansively interpreted by the apex court in Native Plantations versus State of Karnataka versus Native Plantations. Science. Next, but in the above circumstances, petition is allowed. The writ of mandamus issues to OP number 4 to refund rupees 5 lakh, which the petitioner, the subject rupees 5 lakh to the petitioner within a period of 3 weeks, failing which the amount shall carry interest at the rate of 1% per mention for the first month and 2% for the period next following. Okay. So courts reluctantly made it.
During the
registry to send a copy of this order by speed post to OP number 4 before immediate. Yes.
During the period from 2018 till date, the interest,
nothing can be done.
Because that has been kept with the before opposite number 4.
Was it put in a bank?
Because receipt has been given against of 3 page 19.
In the event the said amount has earned interest because of its parking in interest earning scheme or the like, the interest also shall be refunded given to the petitioner. Yeah.
Item 14. May I please, my lords? Here is the case, my lord. The petition of what was appointed as a Sevak in the ST school, my lord, in 1997. Unnecessary to page 18, while continuing as against regular vacant post.
Your prayer.
Prayer for to count the period of service from date of appointment was only either earlier period to grant all service benefits in the meantime retired. I only pray to count the period of the ad hoc period and towards the pensional benefits. To listen on apostolic in this regard that a person continuing in the ad hoc period shall also be counted to pension, and the another judgment of the Supreme Court that the even contractual period shall be also counted for pension. If a person appointed prior to the cut-off date and regular thereafter is entitled to pension by counting entire period.
And one thing,
who have filed the counter melon. They are saying that two persons are there, those who have been allowed with this benefit. So after merger, this Sebika, the present petitioner, is continuing. And all the way in the meantime, he has retired. Only basing upon the recent judgment. They are saying for that period to be counted for the purpose.
I retired on 30th April 2024.
Retired from since 2024.
you entered service on
Sebak, my lord. Sebika. In SC Development School. On my lord, 1797. Thereafter, advertisement issued to fill up depot regularly. Thereafter, advertisement issued by the opinion number 2 to fill up depot regularly under Annex 2 in the 2021. 2001. And the result not published. Even the interview was conducted, no result published. I allowed to continue. I approached on tribunal twice. On tribunal director, if others have been given the benefit, even the result not published, his case will consider. Thereafter, 2007, the regular service.
Niranjana Das.
Niranjana Das.
They have 2004, they are giving regularized. And I was not regularized. For that I reason, I approached my tribunal to consider the case in light of that case, but they are giving me regularized in 2007, my lord. I continue till my retirement. The regular schedule of everything.
Which is the period left out unconsidered?
97 to 2007, my lord. 1797 to
9/10/2007.
7, my lord.
No, 6/10/97.
97, my lord. To that only one paragraph, my lord. Our pensioner also prescribed that should be counted. A rule 18 pension rule also.
Your pension is not
given.
Not given.
Only on the period that I regulated in the 2007, after the cut-off date.
The short grievance of the petitioner is as to non-reckoning of his service from 7/10/1997 to 6/10/2007 for the purpose of service benefits, including the terminal benefits such as pension, etc. First one. Learned counsel for the petitioner submits that a coordinate bench of this court in
Niranjana Das case.
Ananda Das.
Niranjana Das and Anand.
Niranjana Das versus State of Odisha, 2014 ILR Katak 459 has already directed in cases of the kind that the service period of the nature has to be reckoned for all purposes, including for sanctioning of terminal benefits. And therefore, the same relief needs to be accorded to his client. First off, this has not been much disputed by the other side. You do not dispute whether it was taken in appeal. No. Disputed by the other side. In all fairness. First off, it has been a settled position of law that the like cases should be decided alike, and where a set of litigants are granted a particular relief, the other set on the similar pedestal cannot be denied the same, subject to all just exceptions. First, the argued case of the petitioner does not fit into any such exception. Firstly, next one, the above circumstances, this petition succeeds. The impugned order, the writ of certiorari issues, actually the impugned order dated 24/8/2023.
23 minutes. Unnecessary 3.
Annexure 8.
At Annexure 8, issued by the collector, correct at Annexure 8. The writ of mandamus issues to whom?
Opposite not 2, madam. OP number 3, madam. Collector.
OP number.
No, no, sir, 2 and 3. Because 3 may actually instruction from the OP number 2. 2 and 3, madam.
OP numbers 2 and 3.
Madam.
To reckon petitioner's service during the period between 7/10/97 and 6/10/2007 for all consequence or for all benefits, service and terminal. First of all, this order to be implemented within an outer limit of 3 months, failing which it is open to the petitioner to move an appropriate application for taking penal action against the erring officials. That the penal action may include arrest and detention or levy of exemplary costs. Okay.
Item 41.
Yes.
तो ना हमें नाम की
हाँ तुम्हारा
घूमने देंगे
Counter not
41, 42. These 2 items, they're counted to be filed.
41 also covers with the judgment, but retired person 98 days only prayer is 98 days only salary. Already this one decided the issue. I also annexed the order, annexed 9. But my friend Thomas, time counter.
Look into it.
Look, because these 2 matters they have not supplied the file, but however counter is to be filed.
41, 42 in the first week of October.
42, it is only 2.5 months leave salary, have not yet been regularized since 2016.
Tomorrow.
Last 3 times they have taken time. That is
Monday to him.
Monday को
the records are not available, for which he is paying time.
If Monday will come, we will supply by in course of the day.
No, we have many men. We will have it in this second week of December.
My Lord.
Second.
Item 41 and 42.
Item 43.
43 may please, Your Lordship.
Yes.
Here, petitioner is praying for regulation of his service in the post of DEO, my Lord, since he is working from 14/5/2009, my Lord.
All petitioners?
All the petitioners, my Lord.
Data entry operators?
Data entry operators, my Lord.
Data entry operator.
DEO. We considered one similar matter, data entry operator matter.
My Lord, son, 3 days before.
Yes, my Lord, I had
that keeping in view that data entry operator contractual period, that Supreme Court, Patita Pavan Datta Das, that judgment has not come out. On last...
it's covered by the judge. Otherwise also
on ordinary it was filed by the Hon'Ble Apex Court. But it has not been uploaded.
Dharam Singh and I'm giving. Here, Jago, my Lord.
No, Jago, Shripad, Dharam Singh is there, my Lord. On data entry operator, in Orissa case.
My Lord, you have that this one, my Lord. My Lord has passed just 3 days before. Here, where finance department was stating that due to financial exigencies.
That we said, this is covered by the judgment.
Covered by the judgment, but that has not been uploaded, my Lord.
Yeah, this is uploaded. This is my Lord's judgment.
My Lord's judgment has been uploaded.
And Patita Pavan Das has already been confirmed by Hon'Ble.
Keeping in view that judgment, this order was passed.
Correct. The subject matter of these petitions is substantially similar to the one in Rasmi Ranjana Pattanayak and another versus State of Odisha in WP, similar to the one in WPC number 2552 of 2023 between Rasmi Ranjana Pattanayak and another versus State of Odisha, and another disposed of by this court by judgment dated 17/11/2025, wherein the operative portion reads as under.
ରିପୋର୍ଟଟା ଦେଇଛ ରଶ୍ମି ପଣ୍ଡା ଗୋଟେ କପି ଦେଇଥିଲି।
Yeah, just look into that. Next, we have written that similar cases to be treated similarly. I have used the first line. Just now we took that. Is there also a condition that same there? Yeah. In the above circumstances, these petitions are disposed of, granting the same relief as has been accorded to the litigants in the cognate case, which I distribute.
My lord, here rejection order is there, that needs to be quashed, my lord. Annexation 19.
In that we have rejected.
Yes, my lord, rejection order was quashed.
And the impugned all circumstances from the petitions are allowed. A writ of certiorari issues quashing all the impugned orders wherever they have been issued. First off, southern direction in that way.
Here, my lord, only the difference is they have been entered into service by OFN walk-in interview. And finance department concurrence was subsequently not extended. That is the two difference between that case and this case.
No, that also we have covered in another matter where walk-in interview appointment was made. We held walk-in interview is also mode of appointment.
That is the difference between it is my
Same order.
My lord.
Same order. Identical order too. Right? I'll come back afternoon.
I was not present. Reason being, my lord, this court's display board. It was showing 34, I was coming down and 38 reached. And in fact, it has been adjourned to first week of January.
When do you want?
Anytime next week, because other lawyers are also there.
Week of next week. Yes, week of next week. Whether you signed already? Order is signed? Not to enforce that. 38.
I beg your lord's pardon, my lord. Item number 48.
48,
my lord. So there I am appearing for the opposite party number 4 and 5. They are the contesting opposite party. So counter affidavit, I need 10 days time to file counter affidavit. So I have taken consent of Ms. Dipali Mahapatra. She is appearing for the petitioner.
You want questions?
My lord.
Counter to be filed within the 3 weeks.
No.
3 weeks.
I may be pardoned, my
after serving a copy thereof. In this matter?
No, my
some other matters. After serving copy thereof, from the council appearing for the petitioner.
And interim order is there.
Interim order to file. Yes.
I may be pardoned, my lord. Item 50, my lord. Personal appearance there, my lord. The
50.
My lord. I have already filed the complaints, my lord, and she is also appear. Personal present, my lord.
Who are they? Call them. What is this matter about?
That is the matter, my lord. Non-sanctioning of the pension.
Non-sanctioning of pension. Well, for a shortfall of 2 months, my lord, it is not completing 10 years, the minimum pension, my lord. Meanwhile, my lord, after lordship's direction and so also the previous direction, my lord, they have been complied. I have filed the compliance affidavit, my lord.
You have complied with the order?
Lordship, they sanctioned the pension.
Pension is not being paid. Only they have forwarded the pension paper to the controller of accounts.
Yeah.
1511.
1511. They have done that job.
Yes.
So direction I wrote direct.
No, who is the controller?
Control of accounts, my lord. He has not made as a party to the control of accounts. He has made
They have
accountant.
done their job. They have put
Primary school teacher, my lord, sir. Primary school teacher usually control of accounts.
No, control of accounts is the
not required.
They have done their job. Any delay in doing that?
delay.
In what period they were supposed to do?
My lord, he is in charge of, my lord, 5, more than 5, near about 5 posts, my lord. His original post is the headmaster, my lord. And being charged of 2 BO, block education officers of Raghunathpur as well as Jagat Singhpur, my lord. So also as a headmaster of another 2 government high schools for drawing dispersing authority, my lord. That is, and he has joined in 2024. And this matter is not brought to his knowledge, my lord. That is the.
All right, hereafter you don't do it. Within time you should do.
Yes, sir.
All right. The young officer, we should not trouble her.
Justice has entered in.
Compliance is done. They have already sent it on 11.
But no, petitioner has not get.
We are concerned with that. We have not made the pension disbursement.
Control of accounts.
Not a part.
Let it come 1 week after I will make petitioner.
Now whatever they have done is over, na? This matter is disposed of.
Not, my lord, disposed of. Admission.
Serial number?
50, my lord.
50.
50, my lord.
50, what is that?
Your lordship may see your earlier order of paper.
30 LV65. Judgment is complied with.
Lordship.
Judgment complete, my lord. So your lordship directed to. The opposite parties are directed to take immediate steps for releasing the pension to the petitioner as per procedure paper.
Whatever.
Yes, sanctioned the pension and the pension sanctioning authority will issue the pension payment order.
2025 has been complied with. By OP number?
By OP number 4, my lord.
OP number 4.
My lord.
By submitting the pension papers for the consideration of Accountant General.
Controller
of accounts.
He is not a party to the present proceedings.
He is not a party. Therefore, no, again, one more case.
No, my lord. Not required, my lord.
What he will do?
Pension was not sanctioned, my lord.
Not sanctioned because of shortfall.
Shortfall of, my lord, that more than 2 months, my lord. That has been sanctioned, my lord.
What do you say?
And the rest part.
The qualifying period is not over.
Now that is over, my lord.
How?
They have recommended sanction.
They have recommended now.
Yes, my lord.
Is it?
Yes, sir. As per the previous order, we have
No.
that the gap is only 1 month, 23 days.
1 month,
24 days.
23 days.
Days to 10 years. That
For
is
10 years.
minimum qualifying period.
So 9 years plus has happened. 9 years, 8 months.
9 years, 10
months.
And
7
27 7 days.
7 days.
7 days.
Yes.
Now he is eligible to pension.
Yes, sir. As per the previous
Yes,
order,
ma'am.
the minimum gap is, sir, the last quarter. As it is approaching last quarter, so as per previous
direction.
as per the direction, we have
He is entitled to. Is he entitled to or he is not entitled to? You have to tell him, na.
Yes, my lord, he is entitled to. As for my lord's direction, my lord, that lordship glance, my lord, place 37 of the writ petition. That is the direction of the coordinate bench, my lord.
For completion of the minimum period, the said shortage period can be rounded off and benefit can be granted in favor of the employee.
Lordship.
Therefore, in view of this, pension needs to be sanctioned now.
Yes, my lord.
So and so.
OP number, go to the earlier order.
Earlier order, my lord, 31st January, 31/10/2000.
Your OP number?
4, my lord.
OP number 4. Who is the incumbent of the office of OP number 4 is personally present before the court and submits that papers have already been submitted to the accounts.
Controller of accounts, my lord.
The controller of accounts. Controller of accounts. And therefore, now the controller of accounts has to take a decision in the matter, keeping in view first of account. First. Therefore, the controller of the accounts has to take the decision keeping in view the case of the observations in the case of State Bank of Patiala versus Pritam Singh Bedi, 2014, 3 SCC 474, in treating the shortfall of service, qualifying service, shortfall of qualifying service. First up, the controller of accounts shall take a decision immediately, and do the needful on the production of a copy of this order before him. The outer time limit for compliance is 4 weeks. Then the petition is disposed of. Petition stand disposed of now. Petition stand. Whether it was not disposed of earlier?
No, it's his first time, second time.
When about that petition prayer reads at that time. This court-wide order dated 31/10/2020, interim order dated 31/10/2025 had said as that. First up. Accordingly, OP number 4, Timothy so and so is present before the court and submits that already the pension papers have been submitted to the controller of accounts for being processed, and therefore the petition has become infructuous. First up. Next paragraph. Learned counsel for the petitioner submits that in the light of that Patiala case, so written down, na? Okay. Come on. Whatever shortfall there in computing the qualifying service for pension, come on, the same needs to be rounded off to the qualifying period, and thereafter the pension needs to be sanctioned and released. First up. This is a matter for the consideration of controller of accounts, who is not a party to this proceeding. First up. However, his being not a party would not come in the way of granting relief to the petitioner in accordance with law on the production of a copy of this judgment before him. First up. Decision to be taken within an outer limit of 6 weeks. 6 weeks. Registry to send a copy of this order to the controller of accounts, where he is. Bhubaneswar, by speed post immediately for doing the needful action. Mention disposal.
Personal appearance may kindly be dispensed with. The personal appearance of the opposite partner may kindly be dispensed with.
Very dispensed. Now, the appearance of the parties noted. One sentence.
That's it.
Personal appearance of OP number 4 is noted. When officers come to court, you should whole day they need not wait. You should mention in the morning itself. our officers and some. Otherwise, they will have a lot of work.
So we have to try to before launch.
The personal appearance of so the OP number 20, block education officer, and her participation in the proceedings is appreciated. First of all, registry to share a copy, carbon copy of this order with the Srimati Swine Society's copy. Next. Both the petitions are over.
Both. Item 15. Item only item 15.
Only one.
Only one item.
One item. Yes.
So item 30. 31 pass over. Item 31.
May please. That case, my lord, last week it was there. My lord senior has only taken time to clarify his position. Admittedly, he didn't possess. That is that case, my lord. Just to recapitulate. My client appointed in 1995 with the qualification, but his client did not possess that qualification. Didn't have the PG degree, post graduation. That is the appointment in 94. No, that was admitted.
What is the case about? I don't remember.
Oh, sorry. My lord, then
Start from
yes, very small point, my lord. I'm just placing it. The present appellant, I am for Sarveswar Lenka in FAO 470 of 24. My senior is also for the same person.
468 of 2020.
Same person, we both are continuing.
I am for the appellant. Same person.
Serial number 31, my lord.
31.
Three appeals. Three appeals, my lord. Yes. That time, the facts, undisputed facts, I am placing, my lord. My client, the Sarveswar Lenka, was appointed in 1996.
What is the prayer?
Yes, prayer is the order of the tribunal, because two persons claiming for one book. Who is to get? Only one person can get it. So whether our Sarveswar Lenka,
Mr. Swain's client, both you are
our client, Sarveswar Lenka or Kanu Charan. These are the two persons, my lord. So therefore, with this background, my lord, the very short point involved in this case is a purely on question of law.
Why two cases are filed?
Two cases filed by these three cases now before board.
Three cases?
Yes. The first one,
468, 470, and
526.
Yes.
526.
556, sorry, 556.
556, sir. Lead matter.
My lord.
Let us see what is the lead matter. 556. Yes, sir.
My lord.
Same order is challenged.
Same one judgment.
One order is
Judgment, three appeals.
He has filed letter that is her case come. So therefore, I have placed the case.
Two granted cases were filed before the tribunal, and two cases were analogously heard by virtue of a common judgment. That common judgment has been challenged by Sarveswar as well as by Kanu.
Both they had filed.
Yes.
Okay. Your GIC, GIA.
Yes. That was GIA.
Your GIA is?
My GIA is
the 513.
That is, no, my GIA is 513 of 2016. My learned friend's GIA is 5816 of 2018.
Learned friend is both are?
No, Mr. Das.
My GIA case minor 864 of 2012.
Mr. Swain's GIA is
513 of 2016, filed by him, filed by Kanu.
And Dash?
818, that is GIA case number
816.
Yes, sorry. That is.
That's what I was submitting. This was the confusion. My lord, actually, two cases, two GIA cases. 513 of 2016. Wherein? Yes.
Mine is 864 of 2000.
Yes, that is.
In that case, I was a opposite party. I was one of the opposite parties because he filed that.
This is
Mr. Kanu has filed that
864.
Yes.
In that you happen to be one
opposite party.
And 513 filed by Sarveswar. 513 of 16. Filed by Sarveswar. There, he was not made a party because there the order of the director was under challenge. But these two cases heard together by the tribunal. Again, it has come in at one stage, it has been disposed of. It has come to this honorable court in a common order. This honorable court again demanded matter back to the tribunal. Finally, the tribunal has passed this judgment in here, and that is
What they say?
yes. What is the case? Well, in 2 to 3 lines, madam. These two undisputed facts, I would say. 8/9/96, Sarveshwar was appointed. 8/9/1996. And he joined on 29/96. As a lecturer in history. Kanmu Charan Samal, my learned senior client, he claims to have been appointed on 8/9/94
As a lecturer in political science.
and joined on
29/94.
29/94.
By then, he had no requisite qualifications.
What is the qualification?
Yes, the qualification at the relevant for this is Sanskrit institution, madam. Sanskrit institution of two types. This is one is Upasastri, that is equivalent to +2, and one is Shastri, that is called +3.
I heard this matter.
Yes, that is that. Therefore, I am just recapitulating. Everything will be.
Your Lordship was about to dictate the judgment. Because everything has been noted down.
My Lord have kept a.
Your Lordship may kindly see Your Lordship's note.
The note is there in that file.
I had prepared note of.
Yes, everything my Lord have noted. Therefore, I am recapitulating all these things. Put छोटो कागज in a small piece of paper, my Lord have.
There in the correspondence prior to 70, it was 55%, then 48%. That's lower.
No, 87.
Whether it is applicable to
87,
it was
the government has issued a circular saying that a lecturer to be appointed in a Sanskrit institution should have 54% mark in post-graduation. Now, the state government in
That 87 date, circular date.
that I have given it is that is on 15/10/1987.
1987.
Is 39. 15/10/87.
15/10/87.
15th October.
That's all right.
1987.
Percentage?
54. In the meantime, the state government has brought in. The Sanskrit institutions were governed by a separate circulars. But state government by amendment of the Odisha Education Act 1994, they have brought in Section 3S note. Explanation is given there. That I have read to my Lord. Including the Sanskrit institution as a general institution.
Yes.
And the provision for payment of gratuity comes in Section 7D5.
Section 3.
Small s. The definition chapter, explanation. That is at page
number
117 of that book.
117.
117.
Take the book.
Education
manual.
117.
That came into force by virtue of Odisha Act number 13 of 94.
This is an explanation.
Yes.
An educational institution imparting Shastri, Upasastri, Madhyama and Prathama courses of Sri Jagannath Sanskrit University shall be deemed to be a college, a higher secondary school,
a high school or upper
junior college, a high
respectively
school,
for the
and an
purpose
upper
of
primary
this act.
school, respectively for the purposes of this act.
Their required percentage is how much?
There is a rule. There is a rule. Corresponding rules.
1991.
Thereafter, my lord, kindly have a glance to section 7C. 7C.
7C5.
137 page. Capital C.
Again, the institution becomes what?
This became an aided institution.
No, higher secondary or junior college, what?
Yes, that
After
is
3
yes,
yes,
my lord.
sir,
Now this is
so.
called a junior college or a higher secondary school.
Yours is what?
This is, my lord, this institution is having both higher second Sastri, Upasastri and Sastri. This is equivalent to general college, but the nomenclature remains the same. Upasastri.
It becomes a college.
Yes, institution became a college.
Junior college.
Junior college. Name nomenclature remains the same, my lord. Upasastri. For the purpose of this act, my lord, this is junior college or a college, whatever it is.
Your Lordship may kindly see that 7C5.
7C.
Yes.
7C5.
137.
Page
It
138.
starts. No, 37 starts. Section 7C, page 137. This is with regard to the granting aid. Section 7C5. Irrelevant. The equivalency they have again reiterated.
7C.
C5.
Next. Then 5. Yes. Notwithstanding. 138.
138.
Notwithstanding anything contained in any law, any rule, executive order, or any judgment, decree, or order of any court of the following categories of private educational institutions.
There is a non-obstante clause.
Yes.
Then what it means?
This reads, sir, this educational institution shall only be eligible for consideration for payment of granting aid. These are the institutions under the Odisha Education Act is eligible to get granting aid from the government.
Then C.
Then C and D were concerned, my lord. Upper primary school and all this high school not concerned. Higher secondary
college.
C and D. C also.
C and D.
Higher secondary school, junior college imparting instruction or course for higher secondary examination conducted by the Council Higher Secondary Education Odisha or institution imparting Upasastri course of Sri Jagannath Sanskrit University and madrasas imparting equivalent course. Our Upasastri course is under the Odisha Sanskrit University. Sri Jagannath
Sanskrit University.
So it is entitled to grant in aid.
Granted also, as per this act, Odisha Education Act.
Section 7C 5C.
C. D also, my lord, Sastri.
D also.
Sastri. Thereafter, my lord, so for the qualification is concerned, under kindly see. That is, the my lord have written it, everything.
Everything has been written.
Rule ta dile. Rule
He admits, Mr.
Yes.
Pradhan admits that his client has no qualification.
Yes. rules. ଗୋଟେ କପି ଦେଇଥିଲି।
He had 52% in history.
Yes, minor land. 416 out of
Which it is 48.
48%.
48.
As per the rules.
Under the rules after it became junior college.
Junior college.
Yes.
This rule is applicable for the junior colleges. Odisha Education Service, Higher Secondary Branch, Method of Recruitment and Condition of Service, Rule 1991. Rule 14.
In my
Read with 7C5.
Minor.
7C5 C and D.
C and D. C is junior college, D is college. Upasastri and Sastri.
Both are applicable to you.
Both are. This qualification is for this. Because initially this institution Upasastri, later on it became Sastri. They have opened the +3 degree classes.
And when advertisement was also quoted, they indicated 48% of marks. That was the law then. That was the law.
No, 2009 rules prescribed 54%. That your appointment was prior to that.
Prior to that.
Much prior.
And after 87.
This 91 rule was holding the field.
So as on the date of the notification, advertisement, what was the prescribed this one?
This was 48%.
48%.
48%.
And therefore, in the advertisement also, it has been mentioned as 48% for recruitment. For recruitment.
So I had the qualification. He didn't have the qualification.
That is rule 4 under chapter 2D.
Yes, that rule I have given it one.
And it was amended in 1997.
11,697.
Yes, that became 55%.
That makes no sense.
No sense for the purpose of this case.
Yes. Because our client was appointed in 1996.
Yes.
When 91 rules were in
operation. That 48% is of marks.
The tribunal went with the assumption that it is 54%.
54. That 87 circular tribunal says that is the only qualification available. That is the wrong one. Tribunal has dismissed his case because he didn't have the qualification. Dismissed my case because you are not having 54%. 54%. That is the only point.
His appointment was declared as null and void because he didn't have requisite qualification at the time of his appointment.
His appointment is the 8781 circular.
No. His appointment was also made in 1994. 94.
15/10/87.
No.
Sir, 87 circular lost its force after this 91 rule came into
91 rules came into force.
Explanation is offered.
Yes.
Yes.
3.
That is Act 13 of 1994. Act 13 common 14/7/1994.
And he has also committed fraud.
And those are this.
Committed fraud that he didn't have at the relevant time. He has no requisite qualification, but he produced a fake MA certificate, and for MA he was given marks
in the selection.
And that was also taken note of by the tribunal. And his appointment was held to be ab initio void.
My lord,
this is the only last time, my lord.
Who cited the decision in Vivekananda Das?
My senior was. We are not said.
No, we have not.
We are not said.
No, otherwise, how I record that in my order?
My lord recorded because the same day it was there. Another case was argued that was in the course of hearing. My lord, I put that question. Vivekananda's case because that 8781.
That is relating to
8781. School
relating to school.
Appointment of staff in.
I was arguing a case citing that judgment. That is relating to a school.
Which I decided.
Yes.
Yes.
Yes. That is decided.
At the time of entry, he has not.
That was only.
But he has still dated 8781. Trained graduate.
Now what now I have just basic fact I got it.
My lord.
Now what happened?
Now, on the last occasion, or because my lord was virtually dictating something, my senior
wanted to say
senior was to say
yes.
something.
Yes.
My lord, in Macbeth, a drama by Shakespeare, the first stage of the scene, three witch sisters are coming to the stage and they are singing a song. Foul is fair, fair is foul. That has happened here, my lord. Foul has become fair, my lord. Who is producing and produced a forged mark sheet of 4 showing 446. He has been approved, his post has been approved, he is enjoying granting here, my lord. My lord, getting appointment, giving false certificate,
very false certificate.
is uncondonable, my lord.
Where is that certificate?
My lord, that mark sheet of 54%, they have 56% they have shown, and on that basis they have got the granting aid as per the 2000 granting aid order, my lord. My lord, last time you said that the court bench did not give the finding whether that is. Please hold on, please bear with me. My lord, last time your lordship was saying that the last coordinate bench did not give the finding whether there is a forgery or not. But my lord, they have produced a mark sheet showing 446 mark. And when on the call of the High Court, the university produced in the seal cover a mark sheet which is 416. What is the necessary implication, my?
One second. If it is 416, what will be the percent?
My lord, I will come to that point. That is also not applicable in this case. They are totally giving false, misleading submissions before order to confuse the court. I am clarifying point-wise, my lord. My lord, the university produced a mark sheet on the call of the High Court and it was produced in the seal cover and the mark sheet was found to be 416. They submitted a mark sheet and got benefit of granting it by filing a mark sheet of 446, 56 marks. But actually his mark shown by the university on that day was 416, my lord. My lord, another document has come to my mind. Actually, he is not appointed in 1996, as they say. I have got one document.
Who are you?
My lord,
who are you?
My adversary, Sarveshwar. He was not appointed. Rightly, my friend has marked that day. He was appointed in 1994. And both have been appointed, myself and my adversary, both have been appointed in the same day, same year also.
Now, you admittedly do not have requisite qualification.
Requisite qualification. And
what is your case?
My adversary is also not having the requisite qualification.
How you are concerned with that?
Yes.
How you are not in PIS?
No, not PIS, but
how you are concerned?
I admit, I had no requisite qualification at the time of appointment. But I gave it later on as a local candidate. Governing body appointed me. I admit that I have not made any forgery. I have not given any fake marks. I genuinely say my result was out in 1996. I submitted all the documents, requisite document to the governor on a conditional basis, giving a undertaking. I have taken the appointment. So that is my lord. So their mark sheet is a first one, my lord. And his appointment is also first. My lord, this is a document appointed on 8/9/94. Again, it is tempered to be 8/9/1996. Interview date is 2 days. And upon joining date is 2 days. This is another document has gone to my hand, my lord. That my adversary has not completed, has not got the result in 1996. He has passed the MA examination in 1997. His result was published in 1997. Where he got the mark sheet to produce in the year 1996 to get appointment, my lord. So that is I earnestly request, my lord, kindly give the finding, although the coordinate bench has not given, kindly direct the controller for exam Utkal University to produce the original mark sheet and pass certificate. If my lord, he has passed MA in 1996 with 446 marks, I will consider.
Of this honorable
that was given and finding.
Yes,
I say, my lord, I want my mark sheet kindly direct to produce the university to produce the mark sheet. And if it is my lord 446 and he has passed MA in 1996, then I will concede. This is the thing, my lord. Then coming to the second point, my lord. They are very much harping vigorously on that rule, 1991 rule.
Once. Your first point is that their certificate of passing is not genuine. That's your case.
Like, pardon, I didn't follow.
Your first point is that
first point.
No, first point you urged, first submission is that their client had obtained a fabricated marks card.
Yes.
That is your first point. We'll ascertain that.
Right.
We'll call which body has to give that marks card.
University.
University has produced.
Before this honorable court, that last time when shown it, my lord kindly turn to that 817 order.
No, we'll ask one more.
Yes, that
can be satisfied.
Yes.
Yes.
Which university it is?
Utkal University. That I am reading out the
Your Lordship may kindly see paragraph 5. Paragraph 5 of the appeal.
Page
That judgment.
my lord is holding that
What happened?
470.
3 marks cards were produced by the university.
By him. He has got it by RTI and
He
produced
has
it
got
back
it
in
at
date of
RTI. Therefore, this honorable court directed the university to produce the mark sheet of the petitioner. And accordingly, it was produced, and he has secured 416 marks, which comes to 52%.
That was the finding.
That is the finding.
Para 5 and 6. It
And he has challenged that judgment.
Have you filed one document?
Please.
Maxi of court got the
Sir, please.
He has not challenged. My lord, kindly see paragraph 5. Page 203 of my brief. The second brief. Your Lordship may kindly see.
470 No, 470.
What I am see, I have to be fair to him also.
Yes.
Now, suppose if I get the original mark sheet from the university, what objection you can?
No, that was there. That is before this honorable court in a silk cover. In that case, that is
Silk cover.
yes, kindly see. No, not in this case, in the other case. That is why I am reading out the order. This will be exercise.
Number 816 and 817
just read it, please.
I will not go by all that.
No.
I will ask the university to give me your credentials.
Yes, madam. That I am no quarrel, but I am just showing, my lord.
Yes.
Because my lord dictated, I will show it.
Learned counsel Mr. Karuyan very passionately submits that Mr. Sarveshwar Lenka was not appointed in the year 1996 at all. And further that he had produced a fake marks card obtained at the hands of the university.
I don't know, my lord, where from he had got,
You have produced.
You are alleging.
Produced the mark sheets, getting it from another active.
3 mark sheets.
Which are the mark sheets?
One mark sheet it shows 375, another shows 416.
They are from whom?
From the university.
Therefore, we are telling the university.
He has produced, he has created all this problem for me.
First of all.
No,
This is denied by the.
My lord, we are during the exam, they can get for improvement. That's why 2 mark sheets are given.
First, the doubt can be clarified by the university itself by producing the original marks register that is relating to.
But may I read out one paragraph only? There are
No, I will not. I will do this exercise.
Yes, my lord, you can't block me from giving. No, I am not saying it. What the court has said.
Let the court say. My lord. Once a fraud is alleged, I have to examine whether it is true.
That is always there.
Same allegation was made. Same allegation was made.
The original register of marks. Concerning what is that your registration number?
Registration number is immediately.
But same allegation was made.
Where I said in your favor, but I want to hold it against.
This honorable court directed the counsel for the university to produce the mark sheet
And
and
they
the sealed cover.
produced everything seen, but now again I want to see.
Yes. Well, just I am searching the number the mark sheet. That's a small student. That's a slow. More than 9.
The roll number is 2120 216
212056 803.
Registration number 36747 of 1988. This has appeared in the private examination. So brilliant.
That's a sold.
That's all found.
Kindly write down and give.
What he has produced 3 mark sheet, 3 registration numbers.
Registration number, you tell me.
Yes, sir.
What is the correct registration number?
Yes, yes.
I will call all the 3 registration numbers now to know what is what.
Immediately I do.
Where is our Patnaik? Patnaik appears.
Yes, in that case, Mr. Patnaik.
Normally, Mr. T.N. Patnaik is appearing for the university.
He is not party here.
In the other case, when my other occasion, my lord directed Mr. on another Mr. A.K. Nath. Nath has produced that certificate.
Now we will call
Mr. Patnaik, let Patnaik bring it. Same thing to come.
The validity of marks cards in MA history of Mr. Sarveshwar Lenka. Sarveshwar Lenka is hotly contested.
Yes, yes, roll number is there.
Roll number is there.
20.
He studied MA in history. Wide registration number.
This is roll number.
Roll number is there.
Roll number, wide roll number
21205 5C
803.
No,
003.
003.
803.
803. Not less. Let us see this.
This is 803. It is not visible.
And registration number 36747 of 88. Correct?
Yes, ma'am.
Yes, sir. It is the converse or
No. Salvation.
Yes, my land senior is showing that. Yes, my bad. We don't have it.
Yes.
Therefore, the registrar of Utkal University,
that will better control of examination. In they deal with.
No, we'll get it from registrar.
You also may kindly see. See what 416.
Shall reduce or cause to be produced.
See, first.
The original marks register concerning Mr. Sarveshwar Lenka with the above particulars. First off, registry to send a copy of this order to the registrar of the university by speed post immediately. And it also shall share a copy of this order with the panel counsel Shri Patnaik, T.N. Patnaik, for assisting the court in this regard.
I have given the details.
Details you have given. You write down and give that. I'll read.
Sir, it is legible, not legible.
You also may kindly see this.
Then maybe
First.
Not legible.
After photocopy, my lord, maybe.
Right.
This is 803 of 003, that is the
That is 416 mark.
The roll number is there in the tabular form.
Roll number and registration number is also there.
For the ease of understanding, a copy of the letter dated, letter number 8860 of 2012, dated 21/11/2012, issued by the Controller of Examinations, Utkal University, to the Public Information Officer, is appended to this order, so that they will know everything.
Interim order to continue.
Yeah, interim order to continue. Because
Shall
this
I come
matter-
to the second point?
What second point? Let it come. You have no
Year of passing is also important. Year of passing may.
Call this matter on 17/12. So,
FAO matters. FAO matters.
FAO will be 18/12.
But in the second matter, interim order is
interim order. Wherever there is interim order in operation, shall continue. If this in the okay.
Item 44.
Let please a lot.
Item 44.
If I am for OP 3 and 4, I am seeking for an adjournment.
34.
Yes, Lord.
Well, the short point involved here is petitioner is a 12th class student, my lord. Last year
He wants some short accommodation. The first week of January, second week of January 24.
my lord is posting it to
January second week.
my lord may in the December, my lord, because this is a student who has taken a year drop just for correction of his marks, my lord. She has been awarded 0 marks for questions answered.
Second of December. Okay.
Item 45.
It's the request of. Yes.
May I please, Lord?
Yes.
Well, here, my lord, the prayer, my lord, to read the petitioner as 1997 entrant, so as to be covered, my lord, for the getting, my lord, pension under the old pension rule.
When did you enter service?
I entered into service, my lord. The details.
How you gained entry to service? What is the mode of appointment?
Selection was made, my lord, in 1997.
Was it pursuant to advertisement?
Pursuant to selection, employment exchange, nomination being called from the employment exchange.
Through employee?
Yes.
Selection was made on?
Made by 17/11/2006. In between, my lord, that selection was challenged by a various original applications. Ultimately, my lord, the final select list was published on 17/11/2006. And petition was appointed on 1/12/2006. And all those original applications were finally decided, holding therein that they be, yes,
service tribunal.
Yes, they be treated as 1997 entrant when the selection was done.
What happened to that order?
That judgment was challenged by the state before this Hon'Ble Court.
What happened to that?
That order was confirmed.
And went to Supreme Court, confirmed? No.
No, they have not gone to Supreme Court, they have implemented that.
Where is that order?
Well, that order, my lord, that is...
you were one of the parties there?
Yes, sir.
They said you should be treated as a 1997 batch.
Yes.
Where is that?
High Court order, my lord, annexure 4, page 44.
Which paragraph?
That is, my lord, the relevant portion, my lord, page 52, last paragraph. The fact which is not disputed.
Come to 53.
Well,
Pursuant to such selection.
Pursuant to such selection, some selected persons were also issued with appointment orders who joined in the post in the year 1997 and governed under old pension and provident fund rules. The applicant, having challenged the irregularities committed in the preparation of select list, though were the selectee of the year 1997, however, issued with appointment orders in December 2006. The tribunal, by order dated 24/1/2001 in OA number Swan batch,
Go to the order of the OA.
Well, that order of the OA, Miller,
Page 41.
page 41. Para 13.
All the original
Applications are allowed.
Application.
The respondents are directed to treat the applicants as appointees of the 90 or 97. Where is your name?
Well, my name was not there. My batchmates were there. Because I am in the selected manner in the same selection. Though there are batch of applications were filed. So far as my district is concerned, Madam, that is, Madam, the first case, page 27, Binodini Mahanti and others.
No, there are other conditions. Come to para 13.
Well,
there is no arrears of salary for the period prior to their actual service. Applicant shall be governed by the GPF and pension rules of 1992, which were in force when their colleagues were initially appointed. At that time, there was contribution.
Yes.
But we will not give contribute also.
No, I was given appointment. I have not approached the tribunal because some of my colleagues have approached.
That is the mistake you have done.
No, that is correct, Madam. But the case is, I should be treated as 1996.
No.
Entrant, Madam.
With that judgment,
Madam,
you are not a party. Nothing prevented you to go
absolutely correct. Absolutely correct. Absolutely correct.
If that is so,
Madam,
how can we direct?
Pension rule is to be governed in terms of that particular rule, Madam, with reference to the persons those who are appointed during that period. It's not individual, but the pension rule, it is not individual.
Read the pension. If that were to be the contentions.
After this order was confirmed by the High Court,
you are not it is confirmed by the Apex Court and by the International Court of Justice. We'll assume that way. You are not a party or nominee to this proceeding. You are not explained why you did not join the bandwagon.
No, I approached that before coming to this honorable court, I approached the government.
When?
In the government manner, that was earlier manner, I approached the tribunal, annexure 5 page 55.
You had approached the tribunal?
Yes, indicating that I am covered by that judgment.
What it said?
Then direction the disposal of the stage of admission, directing government to consider.
Consider the
yes, page 55. Consumer representation with the
earlier OA number is?
Earlier OA number is 3043C of 2018. 3043C of 2018.
2018?
Yes.
Decided on?
Decided on 4/1/2019.
WP number?
That is this belongs to the present petitioner.
Earlier it came to this OGC or WP it was?
No,
that is
no, madam. They are other persons. Other persons preferred OA challenging the same writ application. But the present petitioner was never the before.
That's right. Earlier WP
was 5820/2014.
Where OA order was challenged.
Yes.
Okay, 2014. 30436 of 2018 you said.
That was the wrong, my lord. That is the application filed by the present petitioner before the tribunal.
You can that way of WP 58.
I approached my lord after the order was confirmed by this honorable court.
One second.
Yes.
The order of the tribunal was 4/1/2019.
No, my lord. No,
4/2/2013.
Wrong letter.
4/2/2013. That is annexure 3.
But then OA number?
That OA number, my lord, 1537 of 2008.
Then what OA number you have given is also wrong.
No, you have given my OA number.
That OA is dated
2018, my lord. 3043 of 2000.
Earlier,
my lord. At Annexure 3, page 25, my lord.
I am asking the number and date.
1536 of 2008.
And batch.
80 of 2009.
All right, 1536 of 2008. One case. Along with other cases.
Along with the batch of cases, my lord.
Dated 4 to
2013. 4 to 2013.
13. There they said all they should be treated as 97 batch members.
Yes.
For the purpose of terminal benefits and seniority, etc.
And pension benefit, yes.
Terminal benefit means pension benefit also.
Madam.
Then that was affirmed by the division bench.
Yes.
DB, order dated
22/11/2017.
22/11/2007.
17.
17.
Yes. 9015, my lord, that WPC number.
WP number 5820 is not. Go to WP number.
Well, page 44. 5820 of 2014.
5820. Yes, 5820 of 2014.
Yes.
This is by the state.
By the state.
This is by the state.
You lost that.
State
and the court said you treat them as 97.
Yes.
Then he was not before the court, but he approached the CH, the OAT.
Much after.
Much after.
It is 2018.
Well, OAT he approached because he had given the representation.
Yes, ma'am.
That you did not consider as usually.
As usual.
Therefore, he came to the OA. He went to the OA.
And consider this within a period of 2 months.
That OA number?
3043.
C of 2018.
Decided on?
This is my lord
2019.
4/1/2019.
Your representation dated?
My representation, my lord.
Consider the representation. Which is date?
Date is not there, my lord.
Date has not been indicated, my lord, in the application.
All right. When they rejected?
But when the matter was directed to be considered by the government, then BO, the block education officer Jagashimpur, referred the matter to directors because in between there was communication. They have said this case is also covered by that case. May I kindly come to Annexure 6, page 56.
No. When your representation is rejected?
My representation, my lord. Annexure 8, my lord, for 24/6/2021.
Rejected on what ground?
Rejected, no, the first order was passed by the director, that is Annexure 8, 24/6/2021. Then government pass order, my lord. The director elementary education pass orders in Annexure 8, my lord. That was
Yes,
the same, my lord. It was not visible, that same, my lord. The same 21/6/2020 on the ground that
Yes, 62 is clarifying, my lord, of that order of rejection.
last but one paragraph, my lord. The finance department in their notification dated 17/9/2005 have amended Orissa Service Civil Service Pension Rules 1992 with effect from 1/1/2005 and brought out Orissa Civil Service Pension Amendment Rules.
All that not necessary. 62, as Mr. Banti said, in 62 they have given a short reason.
That as per the settled position.
You were not born in the service.
Yes.
Mr. Mohanty, in two judgments apex court said, every employee should not be driven to the court. Take out that.
Which one?
C. Lalita.
Lalita. Do we have the citation? Every employee need not be driven to the court at all. If in a given set of facts, the court has decided something, that the benefit needs to be extended to similarly circumstanced employee. That will help 2-3 things. One, they will have faith in the government. Number two, unnecessarily time of the court will not be wasted because courts are already hard burdened, overburdened. On that principle, that those two judgments.
But sometimes it based on the fact of the each case.
No, in this case, he is appointed in the same bench.
But in 2006, 6/12/2006.
Correct.
After 12 years, approached this tribunal.
Correct.
But in 2006, she herself admitted.
2013, the tribunal court, the tribunal gave the judgments. You challenged it, and that was decided in 2017. Yeah, he was under the impression, as a model government, you would extend all benefit.
They have approved in 2008-9.
Right?
So far the OA concerned, tribunal, other petitioners are concerned, they have approved in 2008-2009.
Why they should, that's all. They approached it in 2008. 4/2/2013 is the order of the tribunal. Yes. Then in writ petition, your writ petition was dismissed on 27/11/2017. The employees were under the impression that you being a model employer will extend the benefit of. You can't say few persons in that recruitment process are 1997 batch, others are 2006 batch.
So far the appointment is concerned, can have a glance to Annex 2 for a moment. 2 to the writ application. It is at page 24. So far the present petitioner is concerned.
Yes. Ranjit Balachandra.
Ranjit Bhattacharya. It is dated 1/12/2006.
Correct.
And joined in 6/12/2006.
Correct.
If at all that is so, so after the amendment of that pension rule on 1/1/2005,
no, all others were also, others who were before the tribunal.
They are before the tribunal.
When they were appointed.
They are in 96-97.
No. No. Otherwise, they would not have gone to the court at all. They went to the court because the whole selection process was marred in litigation. The select list came to be finalized only on 17/11/2006. If that be so, you can't say that they were appointed way back in 97. Without a select list, where is the question of appointment?
But subsequently, 6/12, they have accepted it. The conditions of service also they have accepted it.
Correct.
That has never been challenged for a couple of years.
But how can you treat two classes? How can you make what T.S. Nakara says? You can't artificially create the classes at all amongst the same pensioners. Now he is retired.
No, he's continuing.
He is continuing his service. But pensionary benefits,
no, because my lord, unless I will be treated as that, my representation has been rejected that we are not governed by old rule.
No, well, that's all right.
Yes.
But we will be treated only for the purpose of pension. We can be, as you rightly said. Many other consequences will follow.
No, only pension.
Huh?
Only pension.
Only pension.
Yes. That was my prayer also, madam.
Whether it's a contributory pension.
No, it's a regular pension, madam.
After 1/1/2005.
Contribute towards the pension after that particular date. Which was the date when pension policy was revised?
1/1/2005.
1/1/2005.
Yes, ma'am.
So every time he has to contribute to that. How much contribution?
There is a percentage.
Some percentage is
8.33.
8.33.
Yes.
Then where is the contribution from your side?
That is it.
That will come
That will be treated as a new pension.
That will be coming, madam, in the new scheme.
New pension?
No.
NPS.
2000. Your appointment is of 2006.
Madam.
Because of working out equity, etc., they said they should be appointed like this. They were appointed and they contributed to that. Have you contributed?
Well, that instructions have to take because your lordship is absolutely correct. Because the case, my lord, was on a different footing. Because after 2006, my lord, Obviously, they have to get that NPS number, percentage from the matching share of the share of the employee and matching share of the government.
That aspect is there. That aspect tribunal has not treated, the High Court also has not treated.
And government may not in the order may not has not treated.
Order?
In the imperial order may not. They have also not taken that down.
No, that arises now.
Yes.
Because that will be, you will be trying the money from the exchequer.
Well,
court has to do everything to ensure that nobody trusts the honey from the hives.
Even after that order was there, I approached again this honorable court. That is annexed page 65.
Whatever benefit, how you treated other employees. You have given the pension to those people. Now still they are working. Or some are retired.
Some of them must have been retired. Because batch of cases are there.
And I am at the verge of retirement.
Whatever contribution he is liable to make, take that contribution with a reasonable rate of interest and pay the pension so that equity will be adjusted.
Coming under the 2005 rules.
97, 2005
rules. NPS system.
NPS system. That for that he has to make the payment. Whatever the money, DCRG, etc. is there, that you adjust, and if something is more to be paid, he will pay also. Whatever benefit you have given to those who have retired, being parties to the OAT judgment.
Original application.
Same benefit you extend to them and subject to same conditions. Otherwise, injustice happens. His wife will ask why everybody is getting pension, you are not getting pension. He may throw him out also.
No, my lord, we are not standing on the way for others. But fact remains, this is the factual aspect that we should submit it.
Take out that judgment of Apex Court, which said without the employee should not be driven to the court unnecessarily.
Like all of in the Srivattam case.
Sri Lalita.
Sri Lalita only says in page para 29, Sri Lalita.
And that Arvind Srivastava 2015 is.
Yes.
Right now.
15 is Arvind Srivastava.
Yeah. Take them. What were you appointed as?
That is assistant teacher.
Assistant teacher.
Yes.
And what is the date of advertisement?
Advertisement, but the selection was made.
Selection is 17/11/2006. Advertisement is?
Prior to that,
No, it must be prior to that only. Where is that judgment? Go to that OAT judgment.
Page 31.
That was in
Can you give the date of advertisement?
Date of advertisement also.
Without that, I cannot fix that one. No?
The government resolution came person there to annex the selection was made. That was 12/3/1996.
Well, 396.
Yes.
Is 35 minutes. That in a brief outline it is.
Yes, 35 second paragraph.
2015 ECC.
Take now. Basically. Pursuant to government resolution dated 12/3/1996, the advertisement calling for application for appointment to the posts of assistant teachers was issued. First off, the selection process, because of several litigations, was halted, and thereafter the final select list came to be prepared and published on 17/11/2006, followed by appointment of several candidates, including the petitioner herein, wide order dated 1/12/2006. Kindly give attention to me, not to that person. I am giving dictation. Suppose if I commit mistake, what kind of advocacy? All elementary things are to be taught. Kindly be seated, Mr. Manti. Several appointees had approached Orissa Administrative Tribunal under section 21 or 19? 19 of the Administrative Tribunals Act 1985. And one such case is OA number 1536 of 2008. First one. Their prayer was that they should be treated as having been appointed way back in 1997 itself for all practical purposes. First off, the tribunal, wide order dated 4/2/2013, broadly agreed with this view and handed an order, inter alia, with a direction to treat the persons in the batch of appointment as having been appointed as as of 1997. First time. Maybe it was structured on the elements of equity. First time. Next paragraph. The order of the tribunal was put in challenge by the state and its officials in WP number 5820 of 2020, which came to be negatived by a division bench of this court, wide order dated 27/11/2017.
2014.
2014?
Yes.
2014. Petitioner was not one of the parties to these proceedings. First off, he made an application to the OPs for extending the benefit of the said judgments by treating him as of 1997 batch. First off, the said representation was directed to be considered by the OAT in his OA number 3043C of 2018, disposed of on 4/1/2019. First time. However, the prayer of the petitioner was rejected by the OPs, wide order dated 24/6/2021. Correct? 21. First, aggrieved thereby, he is knocking at the doors of writ court. Next paragraph. Learned counsel for the petitioner argues that when all batchmates have been treated as of 1997 appointment, regardless of their actual appointments in service records, there is no reason or rhyme to extend the same benefit to his client on parity basis. First, to the question as to why he did not join the bandwagon of litigation before the OAT or before the writ court, he tells that his client was under the impression that the state, being the model employer, would extend the same treatment as has been extended to batch of litigants, without driving other similarly circumstanced candidates to court process. First off, in support of that, he cites a decision of the apex court in so and so, so and so, and so and so, so and so. First off, so arguing, he seeks allowing of the writ petition. Next paragraph. Learned AGA Mr. Mohanty vehemently opposes the petition, contending that there was absolutely no justification for the petitioner to continue as a fence-sitter, watching what would be the outcome of cases before the OAT, followed by the cases before the division bench of this court. Ordinarily, the claim of fence-sitters is not favored by the courts. The judgment of the order of the OAT, as affirmed by the division bench judgment, are party specific, and therefore those who are not parties cannot seek nectar under them. First, he further submits that even otherwise, petitioner had proved a lot of delay in approaching the OAT in 2018. The DB judgment itself having been rendered in the year 2013 or 14? 2014. First, no explanation is offered for the delay proved, and therefore writ court should not come to the aid of sleepy and tardy like the petitioner. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number one, there is no dispute that the 1996-97 recruitment process was siloed in litigation process, and ultimately the final selection list came to be published only on 17/11/2006. Thus, almost a decade was spent in hope and despair. Petitioner came to be appointed with effect from 1/12/2006 as assistant teacher, and he is going to demit the office on attaining the age of superannuation before long. First, the OAT in OA number 1536 of 2008 and connected matters had handed the judgment order on 4/2/2013 to treat petitioner's batchmates as having been appointed in the year 1997 itself in the peculiar fact matrix. First now, challenge to the same by the state in WP 5820 of 2014 came to be negative by the division bench on 27/11/2014. First now.
2017.
2017?
Yes.
But you said 2014 one second.
14 is the writ application number. Year of the writ application.
2014, the 5820 of 2014.
Yes.
They will also change that. 2017 is disposal.
Yes.
The same has attained finality, there being no further challenge. First off. That being the position, the petitioner could not have been singled out for a discriminatory treatment, he being not a party eo nominee before the OAT or before the DB of this court, notwithstanding. First off. Next paragraph. Ordinarily, in service jurisprudence, all those who have been given appointment on the basis of the same select list are treated as one class for the purpose of salary, emoluments, career progression, and for terminal benefits, subject to all just exceptions, into which argued case of the petitioner does not fit. First, Apex Court time and again had said that when one set of employees have been granted relief in judicial process, other similarly situated set need not be driven to the court as cattle. First off, the benefit granted to one set as of necessity should be extended to the other set in all fairness, more particularly when the state is a model employer in the light of decision of Apex Court in Bhupen, so in so state of Assam, Bhupennath Hazarika versus state of Assam, so and so. In state of Karnataka versus C. Lalita, 2006, 2 ACC 747, followed by state of UP versus Arvind Kumar Srivastava, 2015, 1 ACC 347, this VV is expressed by the Apex Court. First, it is not that the petitioner did not make any efforts at all, in as much as he had filed a representation and that was not considered by the OPs. First off. Eventually, he approached the OAT in OA number 3043C of 2018 that came to be disposed of by order dated 4/1/2019 with a direction to the OPs to consider petitioner's request. First off, the same has been unjustifiably rejected by the impugned order dated 24/6/2021. First off, absolutely the aspects of parity, justice and equity, which the state as an employer has to show to the deserving employees are not have not animated the impugned order. Or first off, the reasoning of the impugned order reflects the colonial mindset of bygone years of the British Raj, and that constitutes added infirmity in the impugned order. In it, first off, in the next one. Learned AGA Mr. Mohanty submits, and this court agrees with the same, that some financial issue would crop up because of change of policy of pension in the year 2005.
Yes.
2005.
1/1/2005.
With effect from 1/1/2005. And therefore, these implications need to be addressed, keeping in view the interest of the exchequer on the one hand, and the interest of the employee on the other. First off, this matter need not be deeply examined by this court, in as much as that the benefits of terminal benefits, the terminal benefits that have been accorded to employees who have retired having the benefit of deemed appointment of 1997 can be extended to the petitioner with the same terms and conditions, by recovering the money, if any, if need, recovering the amount towards pension, etc., if need be. First off, it has to be made clear here itself that the benefit of this judgment is only confined to grant of terminal benefits. The effect of this judgment is confined to, you say benefit of this judgment, instead of that. Effect of this judgment is confined to sanctioning and release of terminal benefits of service to the petitioner in a normative basis. First off. Next paragraph. In the above circumstances, this petition succeeds. A writ of certiorari issues quashing the impugned order dated 24/6/2021 made by the Director,
Elementary Education.
Elementary Education. A writ of mandamus issued to treat the petitioner as of 1997 appointment on par with those who were parties to OA number 1536 of 2008 before the OA. No costs.
Item 46.
Yes.
Your Master, pursuant to your Lordship's direction 16/10/25, the petitioner remained present on 10/11/25 before the medical board. Now they are saying that the medical board, state medical board, will sit on 3/12. And again, I
will sit on 3/12.
3/12.
You speak to the medical board people, and on 3/12 at least let them do.
Yes.
Huh? You went to the medical board?
My lords.
What is the proof you have that you went to medical board and saw the doctors?
My lords, I met them. I appeared before them, my lords. 10/11/25.
What they say?
The state medical board will sit on 3/12.
It's a regular sitting, periodic sitting.
My lord.
Medical board is
whenever order is made, they have to sit and perhaps they have many other cases. They will club together and they will do
together, and it is fixed in a monthly basis, twice in a month.
Medical board to comply with the order dated 16/10/2025 on the next date of its meeting and submit the report as sought from. Petitioner to go before the medical board after ascertaining the date of such meeting. Okay.
Item 47. Item 47.
47.
There is a noting the rejoinder affidavit has been filed, but in fact they have not solved a copy of the rejoinder.
Sir, a copy.
I don't have the file.
The solid copy is still not acceptable.
All right, you sir, one more copy.
All.
Call you the
Retired man is also.
second week of
Retired man also fixed date. Retired man not getting pension.
not getting any pension.
No, provisional pension.
Provisional pension he is getting.
Getting.
That's what. Calling the first week, second week of January 2026. Yes.
Item 48 has been adjourned. Item 49.
Copy for the
49.
Item 49.
Yes, what is this matter about?
Here, my lord, petitioner, student who applied for the admission to BEd course, my lord.
BEd course.
My lord. BEd course. Sorry, BEd course. And accordingly, intimation letter was issued and he was selected and institution was also allotted in favor of the petitioner. Since no admission was given, I approached this honorable court on the ground as per the brochure, well, kindly see page 36. Though petitioner was having all the qualification, but page 36 kindly see, my lord. This is the point for only consideration.
Now they are saying no.
Now they are saying no, though a seat has been reserved. Now they are saying no, admission can be given because clause 3, that bullet number 3.
The candidates who have appeared in their final year graduation examination.
Page 36, my lord.
36 years.
Clause 3, eligibility. Next 3, my lord, bullet number 3, my lord.
She must have passed
Korea as MIL up to HSC or any equivalent level, or have passed Oriya as a subject in specific examination conducted by BSc Oriya of HSC standard, or passed Oriya as a subject in any higher examination.
Passed with Oriya.
Passed with Oriya, my lord. Passed with Oriya in
higher examination. If you have studied in Oriya medium, that is sufficient.
That is sufficient. They say that you have to pass Oriya in HSC.
1 second. Must have passed Oriya as MIL up to HSC or any equivalent level, or have passed Oriya as a subject in the specific examination conducted by BSc. Suppose you are in the English medium, but you take Oriya as a subject. That is also sufficient.
Yeah, in a special examination.
Then Odisha of HSC standard or passed with Oriya means what? As a subject.
Passed
in any higher examination. In PUC, plus 2, etc.
Higher plus 2 or any higher examination.
Degree. What do you have?
I have, my lord, this the special examination of Oriya conducted by the Board of Secondary Education at page 21.
Page 21. Yes.
They say this is not sufficient because this is not up to HSC standard.
It is up to class 8.
They say that this is since
go to page 36 or what is that?
Again, my
eligibility.
May I press my
Yes, Mr. Lenka, just read it.
Yes. He must have passed Oriya as MIL up to HSC or any equivalent level, doesn't matter. or have passed Odia as a subject in the specific examination conducted by Board of Secondary Education, Orissa of HSC standard, high school certificate standard, or passed with Odia as a subject in any higher examination. This is the eligibility criteria. HSC standard is the requirement.
Of Orissa of higher secondary
examination.
HSC means?
High school certificate.
High school certificate standard. What is your standard? Why that certificate?
That says class 8. Okay? That says class 8, page 21.
Class 10?
Class 8.
8. Then it will not be HSC.
My submission, my can see this is the notification of the Board of Secondary conducting two type of examination for class 10 standard and class 8 standard so far as special examination is concerned. Those are passed in English medium schools. Those who
do not know all that. Your certificate does not answer the prescription.
The Board of Secondary prescribe only two type of examination. Those appear in English medium schools having with Odia in 10th standard and 8th standard, taking both them as HSC standard.
No.
But that is clause 1. Kindly see clause 1.
Even in our judicial service,
the HSC standard is a must.
7th standard.
7th standard
yes.
is a must.
7th standard, Board of Secondary Education is conducted.
Why, my lord, I am submitting? Because all the documents I have enclosed for recruitment to the BA institution for the teacher educator in B.Ed course, my lord. The minimum.
That's not the point.
My lord.
Point is,
my lord.
Prescription is simple. It should be passing in Odia as a subject in the specific examination conducted by the BSc, Board of Secondary Education, Orissa, of HSC standard.
HSC standard, as I, my lord, HSC, my submission, HSC standard includes two type of examination, clause 1, that notification I have given. The single subject class 10 standard examination in Odia, Urdu and Happy Early examination class 8 standard language test in Odia shall be conducted directly by board through its zonal office situated in Kotak, Bhubaneswar, Baleswar, Berhampur, Jaipur and Sambalpur. So there are two type of examination was conducted. Those are passed in English medium schools without having Odia.
No, it itself is class 10 standard.
Class 10 standard and class 8, both are conducted by the Board of Secondary Education.
But they want class 10 standard.
It is only HSC standard, my lord.
The high, HSC means?
There is no HSC standard, only two was taken, my lord. One is class 10, one is class 8, my lord.
HSC means what?
HSC, my lord, can you see high school, definition of high school? It includes class 8.
8,
high school
8, 9, 10. The definition, can you see page 123 of the Orissa Education Act? It includes class 8 to 10.
That is the
point for consideration.
I have brought one decision. The Honorable Application. I'm placing my lord. I'll pass your lordship. I'm just placing. Union of India versus Pushparani and others. The paragraph 29.
That was UGC.
No. The total recruitment and admission in courses, different courses here.
What it reads?
Yes, I'll pass you, Your Lordship. Before parting with this aspect of this case, we consider it necessary to reiterate that the settled legal position that matters relating to a creation and abolition of posts, formation and restructuring of cadres, prescribing the source, mode of recruitment and qualifications, criteria selections, evaluation of service record of the employees fall within the exclusive domain of the employer. What steps should be taken for improving efficiency of the administration is also the preserve of the employer. The power of judicial review can be exercised in such matters only if it is shown that the action of the employer is contrary to any constitutional or statutory provisions or is patently arbitrary or is vitiated due to malafide. The court cannot sit in appeal over judgment of the employer and ordered that in a particular course be filled by direct recruitment or promotion by transfer.
Where is the employer here?
No. Here is the employer, the state. State recommends.
It's education.
Yes.
Admission.
Admission by state. Your Lordship,
that is a judgment rendered in service jurisprudence.
Sir.
This is education jurisprudence.
Yes, I have also another direct brought one state of Rajasthan versus Lotta Arun. Administrative action, policy, decision prescribing minimum qualification, education qualification for admission to a course. Here, B.Ed course, he wants, the petitioner wants to take admission. Admission to a course and recognizing certain educational qualification as equivalent to or higher than the prescribed one, held such matters fall within the realm of policy decision to be taken by the state government or the authority vested with the power under any statute.
Correct. Yes. Fully agree. Now policy decision is this circular.
No, policy decision is that he must have a high school certificate standard.
The question is, what is meant by high school certificate? Your policy decision does not answer it. Therefore, court has to decide.
Board certificate?
Yes, that is the high school certificate. The board of secondary, issued by the board of secondary education.
You would have said that way.
And the petitioner, he was reading in a CBSE course.
We do not know all that. Your board of secondary education has issued a certificate.
Yes.
That certificate is, he says it is HSC because HSC includes 8, 9, 10, 10. You have not said HSC certificate of 10th standard. You have not stated that.
We have stated, you'll have to see the criteria. Again, I will read.
Go to 36.
36 page.
The first sentence, my lord, certificate up to HSC. First sentence is up to HSC.
Up to HSC means 8.
Up to. First sentence is up to 10.
He or she must have passed ODIA as MIL up to HSC or any equivalent level. ODIA MIL means in mother tongue. If had he been read in a ODIA school, then matter would have been a different.
No, first part it is. Yeah. There is or distinction.
Or in equivalent level, that question doesn't arise here.
That also.
Or passed ODIA the subject in the specific examination conducted by BSc. Odisha of HSC standard. He is now producing the standard up to 8. He should have obtained the certificate up to high school certificate examination. And he has not challenged that rule, this condition, to declare it otherwise.
Read bullet point 4 in your notification.
The candidate desirous of appearing single subject class 10 standard examination this time can appear in Korea Urdu language only.
There is indication.
Class 10 standard.
Correct.
There is a class 10 standard?
No, HSC means it's a 10th standard.
Yes.
It's a common sense. Since HSC is not defined, HSC includes 8, 9, 10. Technical definition will not help you. We have to go by definition of common parlance.
Then they could have only stated that only HSC standard up to HSC could not have been stated.
We are not interpreting a statute of Westminster Abbey.
No, my lord, I am not saying that.
Some circular.
This is circular. So my only submission, my lord, that since HSC includes 8 times 10, and as per their notification, there are 2 types of examination. So I am petitioner is eligible to be
Take them.
Right.
And passing the motion.
May not be necessary. The eligibility criteria for admission into the 2 years B.Ed course is specified in the, what is this document?
Brochure, that is admission brochure.
In the admission brochure.
Information brochure.
Information brochure. First off, one of the criteria is she or he, first, the relevant criterion at paragraph 3 under the heading eligibility reads as first off. Petitioner, next paragraph. Petitioner who is facing problem in the admission because of some interpretation of the eligibility criteria mentioned above, submits that his client having secured the certificate at the hands of Board of Secondary Education, Odisha, complies with the requirement and therefore admission needs to be accorded. First of all, his certificate reads as under. Next paragraph. You have produced a copy of the certificate here?
My lord, page 21.
Page 21. Reproduce it as it is. Next paragraph. Learned.
I beg your pardon. That's 21 certificate. That is mentioned half yearly language test up to standard, not HSC.
Yeah.
That.
Learned AGA Mr. Lenka vehemently resists the petition, contending that the criterion mentioned under the eligibility column should be read in common parlance, and if that is done, the certificate granted by the BSc to the petitioner is not of HSC standard at all, and therefore no relief can be granted to the petition. Next paragraph. First, you wanted to cite some decisions, so just give them, you will have satisfaction. In support of this, he bends upon 2 decisions of the apex court.
State of
Next one. Having heard learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter, broadly agreeing with the submission made by Mr. Lenka to the effect that the certificate secured by the petitioner at the hands of BSc, Board of Secondary Education, Odisha, is not of HSC standard. First off, HSC means high school certificate, correct?
Yes, sir.
High school certificate. First off, although the course is of 3 years, that is 8th, 9th, and 10th standard, the common sense tells us that HSC course is complete only when 10th standard is passed on and not before. First of all, merely because the entry to the course happens at the 8th standard, the person passing the 8th standard cannot be said to be a candidate who has completed the HSC standard. First of all, it would have been it would have been ideal had the brochure given the brief description of what the admission authorities mean by HSC standard. Is beside the point. First one. Next paragraph. Lenka's reliance on the two decisions, namely
Rajasthan, State of Rajasthan and Union of India versus Pushparani,
do not merit deeper examination because one of them relates to the realm of service jurisprudence and the other relates to the laying down of policy in the realm of education. First, policy as such is already laid down in the brochure, which specifies the eligibility. First off. Next paragraph. In the above circumstances, this petition being devoid of merits is liable to be dismissed, and accordingly it is. Costs having been made easy.
The deposit amount we have deposited the fees since
whatever amount has been deposited
for admission
by the petitioner for admission should be refunded. Who should refund that?
That, my lord, we have deposited in the higher education department. They have taken money receipt, higher education department.
By the higher education department within 4 weeks.
Opposite 1 and 2.
Within 4 weeks. Next paragraph. All the above being said, if there is any concession that can be shown to the petitioner, since he has already remitted the fees and time also has been spent thereto, this judgment shall not come in the way of granting admission to the petitioner as a special case. However, this is not to be treated as a precedent. And liberty is reserved with few people only.
Yes.
Yes.
Your Lordships, I'm given to understand that item 54 was mentioned to be taken up just before rising.
54?
Yeah, by my
Yes.
associate.
Yeah.
Your Lordships, this is that matter that Odisha Staff Selection Commission about the various subjects, Hindi and Sanskrit, which Your Lordships even recently have delivered a judgment, but we are slightly...
Have this matter tomorrow?
Yes, Your Lordships.
Tomorrow, let it be copied on next week, because readings has not been completed as yet.
No.
My amendment petition is aired for the petitioner. And all these are interveners. My IA number 20213 for amendment is
pending.
That has not been allowed.
What is that?
Your Lordship, that's the
That the
issue here.
preliminary examination should be held. That part should be added in addition to my
I think that will require a little hearing because, Your Lordships, what happened is in the matters in which Your Lordships have delivered that judgment, there the people had come immediately. Here what happened, Your Lordships, there was a notification that we are not going to have the preliminary, only mains is going to happen. These people sat for their examination, OMR answer sheet was published, thereafter they come here. And in fact, I have learned also that there is a second application which has been filed, second writ application, where the person stood for that, stood for that interview document verification, and then she comes here. Probably because she thinks shaky.
Madam,
so
you can say afterwards. Now, I will not pass any adverse order against anybody without hearing.
So what happens is they are not only fence sitters, they are trying to somehow think that they are same as the petitioners in those cases. Those were maybe bona fide people who made that complaint. But here, Your Lordships, everything has already happened. And in a...
Now, what is the stage of the process?
Your Lordships, only the final merit list has to come out. In a similar matter, Your Lordships have not allowed the interim to stay and have allowed the final merit list to come. And I think we do hold a similarly good ground because here they are not really serious.
Other candidates.
Yes, other candidates who we have been we have gone through the process and everything. So we are expecting to have our name in the final list.
But subject to outcome of the petition.
Yes, Your Lordships. But the petitioner, that order is also fine, Your Lordships. Let the final list be published and nobody will be given appointment.
Yes.
We are okay with that.
Interim order is that.
May I interrupt your judgment? I am a petitioner there before Your Lordship.
You can interrupt him.
I am a petitioner as well.
He's supporting. There you say help.
Not exactly, don't give that word. Just a minute, I am saying. But Your Lordship have taken up the entire issue which is involved in my case.
No, your case is totally different.
Not different. I want to demonstrate Your Lordship. That case is covered by Your Lordship's judgment where Your Lordship have found out the clause available in the advertisement, the condition available in the advertisement being one and the same. That is, wherever the candidates, valid candidatures are received against the vacancies is more than 1:5 times, a preliminary examination is to be held.
Yes.
By a single notification, in case of both Sanskrit teacher as well as Hindi teacher, they have decided not to hold the preliminary examination. In case of Sanskrit, these group of people, they approached Your Lordships, and in Sanskrit, in Hindi teacher case, Your Lordship have taken up the matter and decided that since the advertisement bears a condition to which every candidate who had made his application has accepted the conditions and is bound by that, they don't have any right. In those cases also, the written examination was held, and Your Lordship relegated the matter back to the stage of preliminary examination. And for Your Lordship's information, after Your Lordship delivered the judgment, the Staff Selection Commission has compared the order, and they have already held that examination in respect of preliminary examination in respect of Hindi teachers post on 16th.
Tomorrow, suppose that if we decide this matter tomorrow.
Yes, madam. Your Lordship decide. All these cases are there. It is covered by Your Lordship's judgment, and it is also covered by 2 coordinate bench judgments where all these issues were relegated back to the stage prior to the original stage because of this.
Tomorrow we'll have.
And it is the one admission of the commission that there is irregularity. And
that is more than
it is the one admission.
You can argue.
That is not.
You want, if you argue now, tomorrow those points you will not be arguing.
Yes. Your Lordship,
you have argued exhausted.
Your Lordship fix it to tomorrow or Your Lordship?
Your Lordship, it comes in the first 5. No, 2 p.m. I'm awkwardly placed. Your Lordship, first 5 minutes.
Monday.
Can the top of the list, Your Lordships.
Monday will be the
convenient for all.
Question is tomorrow or Monday? That is the question.
Let it be Monday.
Letter tomorrow.
Monday 2 p.m. Monday 2 p.m.
Monday.
Let us see. It all depends upon after hearing. If we find difference, we'll hear it separately.
Yes.
Monday 2 p.m.
Monday 2 p.m.
Your Lordship, Monday 2 p.m.
Tomorrow, anytime, your Lordship.
Tomorrow is a division.
Difficult. Monday
Monday 2 p.m.
Monday, it's not many matters. This will take a long time. Going by all the stalwarts, definitely it will take more time. Don't put many men. All right.
Lordship, item 51, Lordship, that is the cash certificate matter, Lordship. Kindly actually take up tomorrow, Lordship. It was not reached today. That is cash certificate matter, Lordship. Yesterday also I mentioned, Lordship directed to post it tomorrow.
When you have to produce that certificate before the authority.
Lordship, actually they rejected my application, Lordship. In this regard, already I have filed the application also. First appeal and also second also I have filed. So there is an urgency, Lordship. I have to submit the same before the counseling, Lordship. That is going in the next week.
When it is? Counseling is scheduled on which date? Where is the document?
Means now the LLB counseling is going in Telangana, Lordship. We are waiting only to submit that cash certificate, Lordship, to get the admission. My lord, item 53, my lord, I'm not getting pension, my lord. Even provisional pension.
Since how long?
For the last 2 years. No, since my retirement.
We expect 2 p.m.
Item 55.
What is that?
Personal appearance matter.
My lord, in item 55, my lord, the writ appeal was there, my lord. It was, yesterday it was listed before the Chief Justice. That order is to be uploaded. May I pray it be Monday that I can submit this?
If the 2 p.m. is reflected, then it will be.
Reflect in the order 2 p.m. Okay? Goes back.
Lordship, item 51 tomorrow, Lordship.
Bring your notes also. Farm notes. It becomes easy for me.
Lordship.
Okay.
Lordship, item 51 tomorrow, Lordship.